Let's not be the case. Ooh.
Mr. Matunzi.
Yeah.
Okay, I want to check if I'm audible.
Oh no, you are audible.
Okay. Good
Right.
morning.
Morning, 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 morning.
Um, I think you must remind members. I don't think they know that we started 9 today.
Yeah, I even wrote on the group that the meeting started 9. I'll
Okay.
just remind them again.
All right. No, thanks.
Recording in progress.
Morning, Chair.
Morning,
Morning,
Mr.
Chair.
Matonsi.
Yes, Chair. The time is now 2 minutes past 9. The only thing is that some of the presenters, I don't see them on the one that we're supposed to start with, Lawyers for Human Rights. So I'm not sure if we'll start or we'll give them like another 3 minutes to join. We'll start
can
at 5 past.
But other stakeholders are in attendance.
Yeah, I see other stakeholders, but not in the order that they're in the program.
No, it's not a problem. We can start. Those that are late will join us when we are proceeding, because as you know that the members must join the 3-line whip at 2 o'clock. And I want to propose to members how we must guide this meeting. Is that okay, Mr. Matonsi?
Yeah, no, it's fine, Chairperson. I think also because we can start, anyway, we're going to start with the submission by the content advisor, so probably the others will start joining while he's busy presenting.
Okay. No, thanks, members, and welcome to this meeting. Greeting to all stakeholders and all our officials, the team that is assisting the Portfolio Committee, Parliamentary Legal Services, and other members of the Home Affairs who are in attendance. There are 4 issues which will firstly request guidance from members of the Portfolio Committee, so that we are also managing this process fairly and give enough time for comments or questions, and also for the presentation. We've noted that this process was advertised for public or written comments, and we thank the response that we've received from all stakeholders, NGOs, individuals, and political parties that have contributed to the response of the Constitutional Court ruling. And we hope that these contributions by stakeholders will assist us to firm up our resolve in finalizing this amendment. We are going to then receive all the presentations, and later on we'll schedule for members to deliberate and process this amendment bill. Last week, we dealt with the presentation by the Budget Office in relation to the upper limits, and you recall that we've resolved that today we'll have a deliberation on that. We will not have that item given the long items that are before the committee, but also noting that the members of the portfolio committee also must join the SONA, or the three-line whip debate, which is coming starting at 3 o'clock, and they ought to travel from their areas of residence. Thirdly, there was an item or a member of parliament from Lesotho who has also submitted for to participate in this committee presentations. We have not satisfied the protocols in relation to members from other parliament to interact with the portfolio committee. We've requested the secretary of the committee to interact with the member of parliament from Lesotho to notify the speaker so that the committee is not being found on the wrong place to have not satisfied process that should allow other members from other countries to participate in this matter. Once that matter has been satisfied, we'll then able to engage with the members from other countries. We draw experience from the last correspondence we have received from the speaker when we're dealing with the Congolese community who wrote to the speaker and requested to interact with the portfolio committee in the sixth administration. And we did, given that process that was affirmed by the speaker, we did allow that community to interact with the portfolio committee. So it's the same process we need to adhere to so that we're not finding ourselves outside the process that should be respected for Parliament. And we will definitely follow that process and advise that member to do that. I want also to draw attention to members that given that we're having SONA, we may need to conclude the public hearing at least by 12:30 so that you allow members to travel from the point of residence to SONA. If we're not going to finish all the stakeholders to present, we ought to reschedule again the public hearing to continue with the presentation. And I want to draw attention to members if that is a fair request, so that we don't deprive members to arrive late at the three-line whip, which is an important session that all of us we must attend. I'm trying to propose that this meeting must end at least by 12:30 to allow members to proceed. Can I get if members agree with the proposal or another suggestions?
Agreed, Chairperson.
Thank you.
Agreed.
Thank you, Chair.
That's fine, Chair.
Okay, thank you very much.
Chairperson.
Thank you very much. Now we can proceed to the second item, which is apologies. Mr. Matonsi, is there any other apologies?
I have not received any other apology, except that I haven't seen the Parliament Legal Service, but I'll be calling them while Adam is presenting. And from the department as well, I only saw Mozi. I'm not sure if the legal service from the department, they are joining as well.
Okay, noted. Mr. Salmon, if you can briefly take us into the details of your summary.
Thank you, Chairperson. Good morning, honorable members and guests. Eddie, if you can just confirm once I've got it, that we are visible. Chairperson, can you see this?
Yes, we can see it, Adam.
Thank you. In total, we received 378 submissions on this bill. Although it's very short, it relates to issues that are close to the hearts of several population groups. So we received from individuals, organizations, civil society groups, legal institutions. There's a total of 350 pages of submissions, advocating for stricter immigration control, stronger enforcement mechanisms, as well as concerns ranging around human rights and administrative efficiency. The organizational submissions are around 150 pages, and there are almost 200 pages of short submissions from the number of individual submissions via email. This is an attempt to overview the high issues. I'm not going into details because we'll get further details from the organizations presenting today. I have also compiled all the submissions into one document for ease of reference, which I can send to members if they need to search through the individual submissions. But this is just a shorter overview of trying to give an overview of the main issues raised. So in total of the 378 submissions, 246 submissions, 65% supported the bill, advocating for stronger border control, stricter deportation measures, and enhanced national security measures. 12 submissions opposed the bill in its entirety, and that's only 3%, citing concerns around human rights, risks of indefinite detention, and constitutional compliance issues. And then 120 submissions, 32% had mixed views, supporting parts of the bill while recommending amendments to enhance due process and legal safeguards in other areas of the bill. The key themes that emerged were judicial oversight and due process, where there were calls for ensuring detained individuals appear before a court within 48 hours with sufficient legal representation. Secondly, that detention conditions such as overcrowding, access to legal aid, and the impact of vulnerable groups such as asylum seekers and minors were taken into consideration. There were national security and border control issues around supporting more biometric tracking and enforcement of against undocumented migration. Economic impact of immigration, and the calls for stricter work permit regulations to balance the need for local workers and businesses. This, strictly speaking, outside of the scope of the bill, but they were raised in many of the submissions. And then there were human rights compliance issues, ensuring that the bill aligns with South Africa's constitutional obligations and international treaties. So the key issues raised and the proposed amendments, in terms of those issues raised before, in terms of judicial oversight within 48 hours, Clause 1A, B and C in Section 34 of the Immigration Act, as they relate to the Immigration Act, relates to how the bill introduces the requirement that the detainees be brought before a court within 48 hours. While broadly supported, concerns were raised regarding the judicial capacity, the case backlogs, and access to legal representation. And the proposed amendments, broadly speaking, were to establish specialized immigration courts with dedicated judicial officers. Secondly, an automated case tracking system to manage hearings more efficiently. And thirdly, or automatic legal representation for detainees without financial means. Secondly, in terms of detention conditions relating to Clause 1A, D, and F, this relates to concerns around overcrowding, inadequate healthcare, lack of independent oversight of detention centers, and many submissions calling for detention to be a last resort rather than the first means of dealing with apprehended undocumented migrants. The proposed amendments were that there be an independent oversight committee to conduct quarterly inspections of all the detention centers, that there are minimum detention standards ensuring proper medical care, legal representation, and humane treatment. These are guidelines enforced by the International Organization for Migration, as well as the UNHCR, United Nations High Commissioner for Refugees. Thirdly, that alternative non-custodial measures, such as supervised release for non-violent migrants. So rather than detaining the migrants, they be put out on a kind of parole or be monitored in terms of their movement, needing to report in regularly rather than have to remain in detention whilst for instance, the applications were still pending. national security and border control, relating to clause 1A F. Many submissions supported for stronger border enforcement, biometric tracking, and stricter visa regulations to prevent undocumented migration. Proposed amendments were that all foreign nationals be registered biometrically upon entry. This is done already, but obviously there are many who come through the country, come into the country and only apply for asylum later. And that there are sometimes glitches in the system where not everybody's biometrics may be captured. There was also a call for strengthening of cross-border cooperation with neighboring countries on migration enforcement. So bilateral agreements that allow for the ease of deportation and repatriation of migrants to their home countries, that these needed to be strengthened. And also that some responsibility be taken by the sending countries, not just South Africa as the receiving country. The fast tracking of deportation procedures for individuals with final immigration rulings. So some expediency and improvement in efficiency in how the deportation process is managed. In terms of economic impact and employment regulations, this is broader migration issues outside of the strict purview of the bill, but they were raised by many submissions, kind of indicating the need for broader immigration reform, not just the single clause that is raised here. And this is also part of the plans of the department as they relate to the white paper on migration, where there's a call for an entire review of both the refugee, immigration, citizenship, and identification legislation as a whole. The proposed amendments were stricter penalties for employers who are hiring undocumented migrants, regulated work permit quotas to balance economic migration and local employment needs. So allowing for a certain amount of unskilled migrant papers to regularize people in particular sectors where migrants labor tends to be used, such as in farm work and sometimes in the hospitality industry, for instance. Thirdly, employer registration requirements for foreign workers, putting more responsibility on employers to ensure that all their employees are registered and in compliance with tax legislation, amongst others. In terms of the right to legal representation, many submissions highlighted the lack of guaranteed legal representation for detained migrants, raising concerns about wrongful deportations and due process violations. And the proposed amendments there are that the state fund better legal aid for all detainees that request representation, and that there be on-site legal advisory services at the detention centers. This has been attempted in the past. And the South African Human Rights Commission, for instance, has had dedicated offices at the Lindela Repatriation Center that members visited last year. And there also seem to be offices of the refugee affairs processing court cases at that center too, but more presence is needed according to this submission. Mandatory information sessions informing detainees of their legal rights. So perhaps there's a vacuum of information available to migrants, both coming into the country and those in detention after being apprehended. Special protections for vulnerable groups. There were a number of submissions from specialized groups such as the Child Legal Center and LGBTQI activists, indicating the risk of detaining children, gender-based violence survivors, asylum seekers, and those on the LGBTQI spectrum. No detention. The proposed amendments for that should be no detention for minors, with placement in specialized child protection centers instead. This calls for better enforcement with the social services in terms of the enforcement of the Children's Act. Secondly, case-sensitive detention policies to ensure safety for LGBTQI migrants. And streamlined asylum claim procedures to prevent unnecessary detention. Again, they're relating to broader need for immigration and asylum reform. Alternatives to detention. Many submissions suggested alternatives to detention, particularly for low-risk detainees and asylum seekers. This relates to Clause 1AI. And the proposed amendments there are that there be supervised release for programs for low-risk detainees, as mentioned before. Many submissions suggested alternative to detention, particularly. Sorry, I mentioned that already. That there were also concerns raised that the cost of detention, its impact on vulnerable individuals, and the need for community-based monitoring systems. So ensuring that the location of these released individuals is known at all times, that they can report to local police stations or community policing forums, for instance. And then other suggestions were like electronic monitoring systems or biometric check-ins. And that one was mentioned already. And then I've just included a list of all the organizations that made submissions, many of whom are submitting today. So the ANC made a submission, COSATU, the Parliament of the Kingdom of Lesotho, as mentioned by the chairperson, the Center for Social Justice, Center for Child Law, Clayville Civic Association, Commission for Gender Equality, the Consortium for Refugees and Migrants in South Africa, the Democratic and Governance Rights Unit, Equal Education Law Center, Human Rights Watch, International Detention Coalition, Mzansi Voices, and I Am Patriot, small community-based organizations, the National African Federation Chamber of Commerce and Industry, NAFCOC, Save the Children of South Africa, Scalabrini Center of Cape Town, South African Human Rights Commission, UNHCR, Lawyers for Human Rights, and Empire 1&1, also a community-based organization. In terms of the breakdown, the total individual submissions, there were 358 submissions verified from submission by individuals, compared to the 20 submissions from organizations. And as indicated before, the 65% were in support of the bill, 3% opposed to the bill, and 32 had mixed reviews. In terms of the main concerns, 68% related to improved judicial oversight, ensuring timely court reviews. 44% related to overcrowding, poor health conditions, and the need for independent oversight. 40% related to effects on local employment and business competition. Excuse me. And 56% raised issues around the need for better law enforcement and biometrics and border law enforcement. The specific clause recommendations were, as mentioned earlier, but here highlighted, were the bill mandated a 48-hour detention review before courts, and that the judicial capacity be addressed through increased number of magistrates handling immigration cases, digitization of the court tracking system, and providing state-funded legal representation. In terms of detention conditions, the bill allows for 90 days, raising concerns about overcrowding and lack of healthcare and access. And again, the proposed amendments, they are independent quarterly inspections, clear guidelines for minimum detention standards, and increased access to Medicare and mental health services for detainees. In terms of the right to legal representation, that there's indication that there's lack of access to legal aid, and that the state provide better legal funding and legal aid, and that immigration officers be required to informing detainees of their rights upon arrest. This also relates to better improved training for the immigration officers, and as well the on-site legal advisory team mentioned earlier. Vulnerable groups again relates to the placing of the children in special care facilities, LGBTQI members being put in sensitive environments, and introducing of legal safeguards against wrongful deportation. So the final policy recommendations in overview relate to mandating the courts to review within 48 hours as required, ensure all detention centers meet the basic human rights standards, and ensure legal aid services. Medium-term reforms. So in terms of the medium and the long term, the biometric tracking of all foreign nationals to enhance border security can be improved in the relatively short term. Regulating of work permit quotas to allow more unskilled and semi-skilled migrant permits, and the introducing of state-managed visa tracking system to prevent unlawful overstay. So improving on the permitting system and the overstaying system. And in terms of long-term reviews, develop a regional migration framework, working better with the SADC and the AU, as well as bilateral arrangements. Implement alternative detention models, including supervised release, and creating a national migration task force to coordinate between Home Affairs, SAPS, and border control agencies such as the Border Management Authority. And that's just a summary of the issue there that indicates that the main issues already mentioned before of judicial oversight, reform to detention conditions, economic migration policy to balance national labor needs, and ensuring that the bill aligns with constitutional human rights protections. Thank you. That's the summary that I have for now. Thank you, Chairperson. I attempted to cover the main issues in as short a space of time as possible.
Okay, thank you, Mr. Salmon. Thanks very much for the brief. We're going to now receive oral submission from all stakeholders. Mr. Matonsi, we'll start with the first four, and then allow members to comment if they questions, and then we'll deal with the other remaining. Mr. Matonsi?
Yes, Chair, it will be Lawyers for Human Rights. I'm not sure if they are in the meeting now. Chair, it looks like they are not in the meeting.
Yeah.
And then if we can go to the South African Human Rights Commission.
Are they in the meeting?
Yes, Chair, we are in the South African Human Rights Commission.
Okay. Thank you very much. You can proceed.
Thank you very much. The Chair, just to greet you and the honorable members present, fellow panelist members that are present here. So maybe before we start, just to ask you questions. We are also having other program after this session, Chair. So if Chair, perhaps we can be released just after 10, Chair, so that we can join. I need to do other presentation, the strategic plan of the commission, Chair. Maybe an officer can assist us with the presentation.
I think you have connectivity challenges. If you can get a better space. And I want to request all our colleagues that you've been allocated time. So let's stick to that time. We don't want to disrupt you when you went outside your allocated time. We're noting the apology. You can proceed, but at least with a better position. So that members can hear you and also the benefit of all the citizens. Thank you.
No, thank you, Chair. I hope I'm audible enough, Chair. Chair, our presentation, Chair, is structured as follows, Chair. The first part, Chair, will just speak to the mandate of the Commission and speak about the highlight of the bill, concern on the bill, and do a recommendation, Chair, and then we do a conclusion. Chair, the mandate, first start with the mandate, Chair. Our submission as the Commission, Chair, is according our constitutional mandate, just to promote and protect and monitor the rights of everyone in the Republic of South Africa. In addition to that, our submission is according also our act that is given to us, South African Rights Act of 40 of 2013, Section 13 in 1B of V. The acts of the Commission states that the Commission have a right to comment on the policies of government and make recommendations. Hence, Chair, we have submitted our oral and formal written proposal, Chair, on the bill. The highlights of the bill, Chair, the bill seeks to adhere to the Concord judgment to ensure that non-nationals are not unduly detained without representation. Also to provide a standard regarding the principle of interest to justice. Chair, on behalf of the Commission, we want to appreciate this opportunity given us but fellow committees to engage and do our written submission that we have done already, and also this oral presentation. Our concern, Chair, on the bill as our presentation, Chair, we think the consultation process, as the Commission, we believe that 19 working days to solicit public participation might lead to the exclusion of vulnerable groups impacted by the bill. So in the main, Chair, we just believe in the Commission that the time was given was not sufficient for those in particular might not have means to participate on the bill, in particular those that are affected. Two, Chair, delay in complying with the Constitutional Court judgment. And the third one, Chair, is to ensure that the bill is full compliance with the rights listed in the Section 35(2) of the Constitution. This is important to prevent future litigation on any other rights within, Chair. The bill, in its current form, does not provide unconditional release when a detention is unlawful. Our recommendations, Chair, will be that the department must ensure that the principle of public participation is adhered to ensure the meaningful participation. It is hoped that it will also assist oral. We also hope that this oral will assist to achieve that. The second one says that the department takes steps in future to adhere to court judgments within the time frames and delays impacts on the foundations of the democracy. The delays impacts on the foundation of democracy. The third one, Chair, is that the department involves and engage more openly with stakeholders. This is to avoid unnecessary litigation that matters against the department, which cost fortune running to almost 100 million. One example, Chair, recommendations want to do, Chair, it's an open discussion and transparent discussion. We have also tried to get an audience of the ministers of the Commission as one of some things that we might also have observed on our place that we do as permanent monitor place of detention. So until this time, Chair, we have not yet heard from the minister. We have also written to the minister with no response. So it's something that I want to recommend, maybe yourself as a portfolio committee, you can deal with it and also engage the minister on the chair. The bill should be inclusive of all the rights in the Section 35 of the Constitution. With that, Chair, we want to take this opportunity on behalf of the Commission and thank the portfolio committee for affording us time and opportunity to submit our written submission as with that, and also have this opportunity to do our presentation, Chair. Chair will be in standby if there might be any clarity or any follow-up questions on the Human Rights Commission. We thank you very much, Chair.
Thank you very much for that detailed presentation briefly. Mr. Matonsi, can you invite the second presenter?
Yes, Chairperson, the second presenter is Center for Social Justice. Center for Social Justice.
Okay, can you proceed to the third one?
Okay. Chairperson, yeah, I think is Prof. Madonsela is in the meeting. She's from that Center for Social Justice. She's also in the meeting. Probably she has got connecting issues. Should I move on?
Okay, can we invite them again? If they are not ready, then they can come after the third one.
Prof, are you able to hear me? Prof. Madonsela?
Okay, let's proceed to the third presenter.
And then that will be Scalabrine.
Thank you. Can you proceed?
Good morning, everyone. This is James Chapman from the Scalabrini Center of Cape Town. Are you able to hear me?
Yes, yeah.
We're able to.
Thank you. Proceed.
Wonderful. If I may just share my screen. I also note that the colleagues from Lawyers for Human Rights have just joined, and that there was a technical difficulty with two links. So apologies for that. Let me just share my screen. Is it appearing?
Yes, that's correct.
Yes, we can see it.
All right. So basically I'm going to be talking to deportation as it relates to the provisions in question, and that obviously it's considered important to every state. But one must look at what's the most cost-effective and humane mechanism for deportation. Also take into consideration those who can and cannot be deported, and how effective is the amendment bill in providing a process and safeguards for those who cannot be deported and must have deported. What are the ways of deporting without actually detaining? So looking a bit into alternatives to immigration detention, and then looking to how the immigration amendment bill might be amended, or what our recommendations are to that end. So let's try to get to the next slide.
Eddie, I don't think we're getting the sound.
Apologies, is the sound not coming through?
Yes, there was not sound coming through.
Okay, the sound is playing on my side.
Okay, can I suggest
Maybe I
that
should just let it play out, because at least there's the subtitles at the bottom. Apologies. But I will share the presentation so people can watch. Apologies again for that. So let me just let's conclude it.
Can I suggest to proceed with the presentation? We'll then deal with this other matter when at least we are on your conclusion. Hello?
Hi, James.
Hi there. I'm going to go back to the presentation if I may. And as I said, are you able to see it now? And apologies for absence of sound. Are you able to see the presentation? May I continue?
Yeah, there's
We're
no
not
able to see the presentation, James. So if we
You're
can,
not, it's okay, maybe I can go to reshare and then the presentation will come up again. Is it visible?
yeah, you can proceed.
Wonderful. Okay. So I just played there the trailer for On the Line, which looks inside South Africa's immigration detention system. And it talks a lot about the really high cost of immigration detention. It also, you saw imagery there of the Lindela deportation center. And so, yeah, but as I say, I welcome viewing of the trailer as well as the whole documentary. We understand, and it is important for states to process deportation, and provisions and regulations must be in place to do so. And the amendment is good in that it ensures that there's timely access to the court. And it also limits detention in instances where it's only in the interest of justice to proceed with detention. If it's not in the interest of justice, then to release. That's positives. But there are some aspects that could be maybe improved upon. So, for instance, Section 34 appears on ordinary reading and interpretation to apply to everyone, inclusive of children under the age of 18. Now, the omission of age considerations in the section should be corrected to give voice to the rights of the child, and also to be in line with the moratorium on immigration detention that was forged by the South African government working together with the International Detention Coalition and other civil society organizations. It's really important to have a good understanding that it's not a matter of saying that children in terms of the criminal justice system, but rather we're talking about immigration detention, which is a administrative civil law matter. Children don't have agency. In most instances, children don't have are not able to actually secure their own documentation. It's all through a parent or through the assistance of social workers or otherwise. It just would make no sense at all that somebody, for being a foreign national, unable to obtain documentation under the age of 18, would end up in detention. And so what should really happen is in any case where immigration detention is thought and it involves a child, instead the person should be referred to the Department of Social Development or relevant child protection assistance organization. And then when it comes to the bill, it should be amended as we suggested, or maybe similar, to say under Section 34(1)(a), an immigration officer may arrest and detain an illegal foreigner over the age of 18 for the purposes of deportation, provided that. And so therefore, really making it clear that under the age of 18, detention is not feasible. There are also certain groups of people that cannot be deported because it is not safe or right in law to deport them. So, for example, a state as a state in certain circumstances can deport those who are not lawfully present in the country. They must also ensure that the person is that they don't detain people who are refugees, including asylum seekers and those seeking asylum, stateless persons, or human trafficking survivors. So when it comes to stateless persons, a stateless person is somebody who's not recognized as a national of any state. So detaining an individual in such circumstances for the purpose of deportation is it is without merit. It would make no sense. What needs to happen is that you need to look into, and the South African government needs to establish which nationality relates. There should be either a statelessness determination procedure if the person really doesn't have any nationality, or working towards securing a nationality for that individual. Similarly, with a human trafficking survivor, human trafficking survivors require support, assistance by the state, where it's involving younger people. It's through the Department of Social Development, and then also the SAPS has a role to play. But crucially, human trafficking survivors are the witnesses in trafficking cases, working together with the prosecution. If you were to deport a trafficking survivor, you are derailing prosecution against human traffickers. So that's why it's so clear that in terms of human trafficking survivors, you should not be detaining for deportation. Not to mention the crucial importance of the re-traumatization of somebody who is a survivor of trafficking. And then coming to refugees, cannot be returned to a place where their life, liberty, fundamental human rights would be at risk. There is provision in terms of South African law, Section 21.4, and the Article 31 of the Refugee Convention. Now, looking at the Domestication 21.4, it says, notwithstanding any law to the contrary, no proceedings may be instituted against a person who's applied for asylum or a person who's been granted asylum. Now, the Constitutional Court in the Ruta case, before the amendments to the Refugees Act, and in the Bore case after the amendments, clarified that Section 21.4, read with Section 2 of the Refugees Act, applied to those who in law, so those who have asylum or refugee documents, de jure refugees, as well as those who are in fact are refugees, so those who have a well-founded fear of persecution or fled events seriously disturbing the disrupting to public order, but haven't yet been documented. So those who wish to apply for asylum but are yet to apply for asylum are also protected. And penalization, one of the most extreme forms of penalization would be the detention for the purpose of deportation. Not to mention that would be a violation of the real bedrock of refugee law, Section 2, which says you can't return somebody to persecutory or war-torn environment. So how should the Section 34 be amended? We recommend that it is amended in such a way that it protects these particular categories. So without the need for a warrant, a immigration officer may arrest illegal foreigner or cause him or her to be arrested, provided that the officer ensures that they fall under those that fall under the refugee definition, stateless persons, and survivors of human trafficking are released and are referred where appropriate. Immigration officer shall for those not in these categories, and then it continues as the Section 34.1 is in place. Then I have spoken to, and the clip, and apologies again for the absence of sound, but the clip speaks to the really high costs of immigration detention for the purpose of deportation. It's incredibly costly there. That same money that, as you saw with the Human Rights Commission, over 100 million is spent in a year. It might be even as much as 150 million. If you look at the fact that it costs 51 million just to run Lindela, it cost the state 52.8 million a 5-month period, as reported in 2024, for deportations. It's millions upon millions of rand that is being spent. Money that could have been spent and should, we would posit, be spent on other things like civic services, birth registration, passports, IDs, addressing some of the fundamental backlogs that the department is facing. Let's say digitalization, improvement of systems. At present, as I said, the Section 41, which is identification, followed by Section 34, addressing immigration detention. Every step along the way is at cost to the state. The law also supports that detention is not required. I mean, we see with the proposed amendments that it talks about where it's in the interest of justice not to detain. In the older case, the Supreme Court of Appeal held that you have to apply discretion as to whether to detain, and a blanket policy would be unlawful. Section 41 speaks to that. One should only really detain as a last resort. That's what the Immigration Act says. It says that only where it's necessary. So it says in terms of Section 41, a foreign national, the immigration officer may arrest thereafter, if necessary, detain him or her. So that strongly implies that it's only really as a last resort. And that's in keeping with international best practice, not to detain unless as a last resort. Now, immigration officers in exercising the discretion to detain should apply the law and exercise in favor of freedom. And that again comes from that same case where it talks about the older case where it talks about in favor of freedom. Discretion should be in favor of freedom. So we would recommend that section 34(1)(a)(h) is amended to say, when exercising discretion to release under sections A, C, and E, so section 34(a), C, and E, discretion should be insofar as possible exercised in favor of freedom, and that's in keeping with case law. Okay. Now, what are the alternatives to immigration detention? States adopting alternative detention save up to 80% of the cost of immigration detention through adopting alternatives. And we see that, for example, in Portugal and other countries which focus on alternatives to immigration detention. Home Affairs in the past has spent, and I mean this, I know it's an old statistic, 2013, a third of the department's budget approximately was spent on immigration detention. So it is likely that a similar proportion of the budget is spent currently, given the hundreds of
Mr. James,
yes, indeed.
you must work on your conclusion because we have the already written submission.
I beg your pardon. Okay, I will conclude. Yeah, thank you very much, Chairperson.
I did not want to interrupt, but I think we're forced to do that. We have cautioned earlier on that just summarize the presentation because already we have a written submission, please.
Okay, thank you very much. Just to say that we would support that alternatives to immigration detention are adopted, including self-deportation, provision of a notice and people reporting, release on surety as two strikes principle. I just wanted to emphasize this, that if you give a notice for somebody to depart, and if they depart, that's at their own cost and saves to the state. If they fail to depart, then one can maybe detain the second time. So it's two strikes principle, and community care residential alternatives. And then just to say that section 34 includes a reference to after considering and exhausting alternatives to detention. Thank you very much. Apologies for going over time. Thank you.
Thanks very much. The reason we requested content advisor to give a brief, it was also to assist our presenters to zoom into key areas they want to emphasize for members to note. Thank you very much. Can we now move to the fourth one, Mr. Matonsi?
Yes, Chair, Lawyers for Human Rights, they've joined. So if we can go back to them so that they can make that presentation. Yeah.
Okay, thank you. Okay, they can proceed.
Good morning, Honorable Chairperson and honorable members. We do sincerely apologize for joining late. We were on the wrong link. Our sincere apologies for that. I'm just going to share my our slide, our presentation. My name is Nyeleti Baloyi. Please let me know if you can see the presentation.
Yes, we can see it.
Thank you very much. As mentioned, my name is Nyeleti Baloyi, and I am joined by my colleague, Ms. Zeketelo Qhele. We will be representing Lawyers for Human Rights as well as the International Coalition, the International Detention Coalition. So Lawyers for Human Rights is a nonprofit organization that was founded in 1979 by activist lawyers, and we have been dedicated to promoting and protecting human rights in South Africa. Our work spans 6 key areas to promoting and protecting human rights in South Africa. Apologies. in South Africa, and our core component of our work involves impact litigation, legal advice, and law reform, all aimed at developing the law to align with the rights enshrined in our Constitution. Through our law clinics and advice offices in Johannesburg, Pretoria, and Durban, we provide legal services to vulnerable groups across the country. This on-the-ground presence allows us to identify emerging trends and strategic issues, informing our litigation and advocacy efforts, particularly in matters that would benefit from legal reform. The International Detention Coalition is a global network comprised of members in over 75 countries. It is dedicated to challenging the practice of immigration detention and championing rights-based alternatives. It does work across Africa, the Americas, Asia Pacific, Europe, and the Middle East, as well as at a global level. The IDC collaborates with its members and partners such as Lawyers for Human Rights to conduct advocacy and research, build coalitions and capacity, and foster opportunities for collaboration. This work aims to reduce and ultimately eliminate immigration detention, promoting effective and humane alternatives. And IDC has partnered with Lawyers for Human Rights historically, working on issues of immigration detention nationally as well as at a regional level. Our presentation today will be based on our written submissions that we made to the committee in November 2024. I particularly will deal with the interest of justice criterion. I'll first speak on the general comments on the bill, then speak on the interest of justice criterion, and my colleague Ms. Cele will speak on alternatives to detention, as well as highlighting the IDC presentation, and then we will conclude. The international law it unequivocally establishes that detention to be lawful and avoid the designation of arbitrary must adhere to specific standards. These include lawfulness, the pursuit of a legitimate objective, non-discrimination, necessity, proportionality, reasonableness, and compliance with international procedural and substantive safeguards. The concept of arbitrariness extends beyond mere illegality, encompassing injustice, unpredictability, and inappropriateness. Therefore, any detention must be justified by a demonstrable necessity and proportionality. So the amendment to the Immigration Act came to be on the basis of the two constitutional court judgments, which proposed the amendment of Section 34 of the Immigration Act. And this has profoundly impacted South African immigration law, introducing crucial safeguards for individuals facing deportation. These landmark cases challenge the constitutionality of legislation permitting administrative detention without judicial oversight for immigration purposes. By rigorously examining the compatibility of such provisions with the rights enshrined in Section 12 of the Constitution, which speaks on the right to freedom and security of the person, as well as Section 35, which deals with detention, these judgments have set significant precedents for the protection of individual liberties and the fair administration of immigration laws. Specifically, these judgments have established that Section 34(1) of the Immigration Act grants excessive discretionary power to immigration officers, allowing detention without adequate procedural safeguards. They have also mandated judicial oversight of any detention pending deportation, guaranteeing access to procedural rights, including the right to appear before a judicial officer within 48 hours, the right to legal representation, and the right to challenge the lawfulness of detention. Furthermore, these rulings have established the interest of justice criterion as a pivotal factor in detention decisions, limiting detention to truly exceptional circumstances and setting a limit for such detention. Now, I want to go forward to speak on this interest of justice criterion. Although there is the proposed interest of justice criterion, the proposed amendments incorporation of this interest of justice criterion into the context of migrant detention raises significant concerns. While the term interest of justice poses inherent flexibility, its application demands precise definition and clear guidelines to prevent misuse. The complexities of this term are evident in its application within existing criminal procedure, where its interpretation can vary significantly depending on the specific context. The Constitutional Court has consistently and emphatically stressed the critical need for clear legislative guidance when discretionary powers, particularly those concerning detention, are granted. And we go more into detail in our written submissions in page 22 till page 23. The current bill's conspicuous absence of such guidance, particularly concerning the interest of justice determination, creates a substantial risk and of arbitrary detention and unjustifiably infringes upon fundamental constitutional rights. There is a need for clearer legislative guidelines. The interest of justice criterion as applied to immigration detention must be meticulously defined and implemented to avoid arbitrary and unjust outcomes. The Constitutional Court has repeatedly emphasized that legislation must not only respect constitutional rights, but also provide explicit guidelines to ensure that any limitation on those rights are demonstrably justifiable. The current bill's failure to provide such explicit guideline and guidance, particularly regarding the discretionary powers granted to immigration officials in determining whether to detain a migrant or not, is a fatal flaw. This lack of clarity undermines the spirit and purpose of the Bill of Rights, as articulated by Justice O'Regan in the Dawood case. The unfettered discretion granted to immigration officials without clear legislative discretion risks unjustifiably infringing on the rights of individuals without adequate safeguards. This directly contravenes the Constitutional Court's pronouncement on the necessity for clear legislative guidance to ensure that discretionary powers are exercised in a manner consistent with the Constitution protections. Therefore, the bill in its current form fails to meet the constitutional obligation of appropriate protection and guidance. Our recommendation for improved legislation is that any detention should be demonstratively necessary, as indicated by my colleague from Scalabrini. It needs to be proportionate. It needs to be respectful of individuals' rights, including access to legal counsel, healthcare, and basic necessities. Clearer and more precise legislative wording, such as the proposed alternative wording in our written submissions proposed in pages 23 to 24, are crucial to achieving this and upholding the integrity of our constitutional framework. Thank you so much for your attention. I will now hand over to my colleague, Ms. Cele, who will be making a presentation on alternatives to detention. Ms. Cele?
Good morning, Honorable Chairperson and members of the committee, as well as my colleagues.
I must indicate to members that they will be doing 2 presentations. I was informed by the Secretary of Parliament, of the committee. So you must not be surprised on the time allocation. Thank you. Proceed.
Thank you, Chair. I will focus specifically on the explicit exclusion of alternatives to detention in the bill. Just to echo briefly what my colleague has said, as well as Scalabrini, the rationale behind our suggestion for the inclusion of the ATDs is because we believe that detention should never be used as a deterrent or a tool for migration control. Instead, we believe that policies must reflect a rights-based approach that basically prioritizes the protection of vulnerable individuals, such as children, trafficked persons, and asylum seekers at the risk of persecution in their countries of origin, but also that it would ensure a fair and efficient procedures with regards to determination of detention, even at administrative and judicial levels. We believe that the present amendment of the bill, like my colleagues have said, it does introduce an interest of justice criterion, which basically provides some guidance to immigration officers and the courts in exercising detention powers. However, we believe that this provision only tangentially touches upon the possibility of determining whether alternatives to detention are available in particular circumstances. It does not go far enough as to establishing the framework for effective and cost beneficial, but also a rights-based migration management. The bill is currently curated sort of create a vague caveat in respect of the possibility of ATDs in that they would be applied or considered when they are possible, practicable, or available. But the bill must elaborate on the extent of the exercise of these discretions. Essentially, I think we believe that it should give a criteria or a guideline relating to how an arresting official, for instance, may come to the decision that an ATD is not available, practical, or possible, because if not, then it leaves a disproportionate discretionary power in the hands of migration officials to sort of detain a person without ventilating those alternatives or exercising in this discretion with the gaze of favoring the liberty of the person. Subsection 1A also establishes that an immigration officer may arrest and detain a foreign national for deportation purposes after assessing whether the interest of justice of the release of such a person is subject to reasonable conditions. While we welcome that measure of recognition of non-detention measures, the wording remains unclear regarding the criteria that would allow for these measures, because the rest of the framework, as it stands presently, places detention at the top of the inquiry, and without clear guidelines, the provisions risk being inconsistently implemented and ignored in practice, as our jurisprudence would show. So within that rationale, we strongly urge the committee to consider various ATDs and explicitly spell out their criterions on the bill, but also further making sure that they are subject to challenge and judicial review. Our colleagues at IDC highlight that South Africa is a signatory to quite a number of key international human rights instruments, including the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, and the CRC and the OPCAT, among others. What we want to point out is that these instruments emphasize that detention should be a measure of last resort, and that liberty must be prioritized wherever possible. So we believe that we submit rather that the bill should align itself with these principles, especially if possibly it can sort of incorporate the soft laws, the soft international law into that, such as the 2016 New York Declaration on Refugee and Migrants, which underscores the need for states to implement ATDs where appropriate, Objective 13 of the Global Compact on Migration, which calls for states to ensure that detention is used only as the last resort and that ATDs are prioritized. General comment number 35 of the United Nations Human Rights Committee, which affirms that any decision to detain must consider alternative measures on a case-by-case basis and not rely on broad mandatory rule for entire categories of migrants. But also we want to emphasize that the Human Rights Committee further emphasizes that the states must take into account further less restrictive means of achieving migration control. I think the premise of the bill should be centered around the rights-based approach as opposed to using detention as a deterrent for migration issues. We have a few recommendations for ATDs which are further clarified in our submissions from page 28 up until paragraph 2055. We believe that, for example, we can use open accommodation centers, community-based supervision and case management institutions. We can create reporting obligations on both the enforcing parties as well as the migrants. We also recommended state-funded bail mechanisms, but also release pending voluntary returns. We believe that for instance, if we start looking at an example of release pending voluntary returns where individuals are not eligible for asylum, for instance, or any other immigration status, but do not pose a security threat, a structured voluntary return program should be prioritized over detention. But also these, I think you'll see in our submissions that we make examples with regards to different contexts in jurisdictions where evidence has shown that there are benefits to alternatives to detention. We believe that it is cost effective in that they are significantly less expensive than maintaining detention facilities. This allows for the redirection of fiscal resources to other critical areas. It could be border management or social services that can also be attached to the alternative to detention. But also we found evidence that it increases compliance in that individuals that are placed in structured ATD programs, sort of demonstrates a higher compliance rate with the immigration processes. This sort of, in other contexts, it has shown that it reduces the risk of absconding, but also it ensures that there is follow through and finality in the immigration processes. But also over and above that, just to go back to the obligations towards international human rights standards and protection, we believe that the ATDs ensure that vulnerable individuals are not subjected to conditions, degrading conditions or inhumane conditions that are often associated with immigration detention. Honorable Person, as I conclude, believe that the inclusion of ATDs in the bill is not just a matter of legal compliance. We believe that it's a matter of dignity and humanity. Immigration detention, as I said earlier, should never be a default response to irregular migration, but instead, we believe that South Africa must adopt a rights-based approach that prioritizes the protection of these individuals while ensuring effective and humane migration management. So our submissions with regards to the ATDs, in essence, is that we urge the community to strengthen the bill by explicitly incorporating ATDs as a primary consideration in all migration detention related decisions. Thank you for your time.
Thank you very much for the presentations, colleagues. Mr. Matonzi?
Chairperson?
Yeah,
the next one that will follow is Center for Social Justice.
Yeah, can you receive the last one? Then we invite members to comment. Thank you. Center for Social Justice.
Hello?
Yes, you can proceed, Prof. Thank you.
Thank you, honorable members, for the privilege to present in support of our submission, which we submitted in November last year. Honorable members, it is a huge honor and privilege. Please let me know if you can see the presentation.
No, not yet, Prof. Yeah, I think we're now, yeah, you can proceed. We can see the presentation. Thank you.
Right. Thank you, honorable member. Greetings to everyone in the room, including colleagues. As I've indicated, I present on behalf of the Center for Social Justice at Stellenbosch University, and we're exceedingly grateful for the privilege to make this presentation. It highlights aspects of a submission we already made in November 2023 in reviewing the Immigration Amendment Bill. And this followed a roundtable that we convened on November 14, 2024, at which the Department of Home Affairs was represented by Advocate Moses Malagate, who presented the keynote address, and then colleagues from other institutions, as highlighted on the screen, also made presentations. I do just want to indicate that as many of our colleagues have indicated. Hello, can you still see me?
Yeah, we can hear you.
Okay.
You can proceed, Prof.
Thank you, sir. We welcome the initiative by the Department of Home Affairs to finally comply with the court judgment in the Lawyers for Human Rights cases. Our presentation, both the written representations and what I'm going to say briefly now, just focuses on understanding that one size does not fit all. We believe that the Department of Home Affairs has correctly responded to the judgment, which primarily found the existing immigration bill wanting because it unfairly discriminated between citizens and foreigners insofar as access to justice is concerned, as provided for all in Section 35 of our Constitution. So our review is purely from a social justice lens, looking at, does the approach that says one size fits all comply with the social justice dictates of the Constitution? Just briefly, honorable members, we believe that social justice is concerned with embracing the humanity of all through equal enjoyment of all rights and freedoms, reflected in just, equitable, and fair distribution of all opportunities, resources, benefits, privileges, and burdens in a society and between societies. At the core of social justice is embracing the humanity of every person so that nobody finds it harder than others to exist in society, and nobody should bear more burdens than others. And of course, our authority for this comes from constitutional court judgments, such as S versus Makwanyane, where it was said social justice is a dimension of Ubuntu. And Makwanyane basically said the principles of Ubuntu should form the foundation of our transformative constitutionalism practice in South Africa. And that includes transformative governance by yourselves. So we already know the court declared the distinction between foreigners and locals is improper. But what I want us to think about are two things. One is the issue of one size fits all. But the second thing, honorable members, is it's an illusion to think that our immigration law deal with foreigners only. They deal with anybody who's suspected. This particular section of the Act, which is Section 34 of the original Immigration Act, deals with anybody who is suspected to be an illegal immigrant. The Minister of Home Affairs recently and justly responded to a young person who appealed to the minister on the platform called X, used to be Twitter, and said for many years she's not been able to get an ID because she's been sent from pillar to post because her mom died before she was born, and then she's been sent from pillar to post. So now we should understand that in the current law, if she were to be arrested, she would be detained and would be treated as a suspected illegal foreigner until she can prove her. The Act then provides, currently the bill provides for what processes would follow that would enable her, let's call her Jabu, would enable Jabu to prove that she's not a foreigner and prevent detention. And this is where we come in. Our emphasis is on the tools that we're providing. Will they be easily accessible to everyone, whether they are rich or poor, male or female, pregnant or not pregnant, disabled or not disabled? Honorable members, we must remember that in Chisuse, the Constitutional Court, represented by Justice Kampempe, said the following: citizenship in South Africa has since its inception in the early 20th century been deeply fraught. Political, social, and ideological tool used to define access to membership of the South African polity. The systematic act of stripping millions of Black South Africans of their citizenship was one of the most pernicious policies of the apartheid regime, which left many as foreigners in the land of their birth. The advent of the constitutional dispensation established South African citizenship as a constitutional precept based on equality. Now, what we need to know is that that stripping of millions of Black South Africans of citizenship still exists. And because those who were stripped, they still walk among us without IDs. And this is something as public protector I discussed with various ministers of Home Affairs. Now, the justice risk today stems from the fact that injustices similar to the past may be achieved through impact unconscious policymaking and law reform that fails to recognize diverse social contexts that lead to extreme adverse impact on some, particularly those who exist at the axis of interlocking inequalities, as observed by the Constitutional Court in Brink versus Keshoff and Mahlangu versus Minister of Labor. Again, I'm coming back to the case of Jabu. If she was caught up, she's a female, she has no money, and hence the issue of access to legal representation that we have highlighted in our presentation becomes important, because although this law is made for all, it needs to be retailored for all. And that's basically is what we focus on at the Center for Social Justice. My colleagues have already highlighted all of the international norms that we need to be guided by. Some of them relate specifically to immigration, and some of them, like the International Convention on the elimination of all forms of racial discrimination, International Convention on the elimination of all forms of discrimination against women, the Convention on the Rights of the Child, and the International Convention on the Rights of Persons with Disabilities. Those apply too, even though they don't specifically deal with immigration. Domestically, of course, we're bound by the Constitution, Section 12 and Section 35, and we are bound by the jurisprudence that has emerged from our Constitutional Court. I want us, insofar as the jurisprudence is concerned, to just bear in mind the need to be multifocal in the way we deal with humanity and multidimensional. Some talk about intersectionality, which is what Mahlangu says. Basically, intersectionality would say that all of these laws that we pass with good intentions might have a more adverse impact on those whose inequality is exacerbated by the fact that they suffer an intersection of inequalities. They don't have money. They're female, maybe pregnant. Some of them are children. Some of them are older persons. Some of them are persons with disabilities. And therefore, basically, we're warning against the danger of a one-size-fits-all approach. And we're not suggesting the Department of Home Affairs or you, honorable members, are trying to be harsh to certain sections of society. We're just saying it's important that we tailor things for everyone. And we saw that with COVID-19, that if you go for a one-size-fits-all, some are thrown under the bus. We gave you a tool for achieving what we suggest should be achieved. And it's called a Social Justice Impact Assessment Matrix. And it asks 9 questions, which we've now completed to 8, which before you sign off on any law, you have to look at constitutional objectives congruence. You should look at who are the targeted beneficiaries or the people who are targeted for regulation. Does it differentiate fairly? For example, pregnant people, people with disabilities, children. Have you used disaggregated data in planning with understanding of who will be impacted with this law? For example, people keep talking about it will affect foreigners. No, it will affect a whole lot of people. But even if it were going to affect foreigners only, these questions are still going to be asked because it won't affect everyone the same. If you have money, it will affect you slightly differently. Equitable advantage or privilege, a restitutive element, avoidance of harm if there are available alternatives. And some people have spoken about avoiding detention, for example, if the same aims could be achieved without detaining people. And then does it provide for mitigation or compensatory strategies for those who might not be able to be regulated equitably? So again, for us, here's the issue of access to justice, that instead of relegating it to regulations, it should come to the act itself. And then the last one is just meaningful engagement. Has everyone who's affected or will be affected by this law been consulted? We've highlighted here among these 8 dimensions, only 3. The one on fair differentiation, that we think there has to be differentiation for people who won't have money to hire lawyers, for vulnerable people such as pregnant women, people with disabilities, and children. And the issues of restitution and compensation strategies are not particularly valid for this particular bill. We have looked at this bill and we've seen DHA and you, honorable members, have done your best in regarding strict compliance with the Constitutional Court injunctions in the Lawyers for Human Rights cases. So strict compliance. But if we're looking at substantive compliance, this is where our colleagues and us would like you to do. And this is about then doing what the president said recently in his State of the Nation address. Let us work together to establish a nation that works for all. A nation that works for all understands that we're not the same, and that sometimes things that are tailored with intention to affect us all advantage some and disadvantage others. We saw that with the COVID-19. And with this act again, yes, we now have a draft that does not directly discriminate against foreigners by not giving them the same due process that is dictated by Section 25 of the Constitution and the protection that is dictated by Section 12 of the Constitution. However, within this group that will be affected, we are saying that this benefit that you're now extending will not be enjoyed equitably by all, because those who don't have money will not be able to get that lawyer within that 48 hours. Those who are pregnant need provisions that take into account their specific circumstances. And therefore, we suggest, number one, an amendment that does not relegate access to legal services, legal and language services to guidelines, puts that squarely in the Act itself. So consider redrafting Section 1A to develop clear, equitable criteria for interests of justice assessment with training of immigration officers and court personnel on implicit bias and cultural sensitivity. We think that a new clause could state the following, honorable members. When considering the interests of justice, the immigration officer should take into account risk to the public, flight risk, access to legal representation, community ties, and international human rights obligations. And of course, strengthen that judicial review within 48 hours. We also suggest, honorable members, that you make it a practice that you apply this social impact assessment tool that we have recommended to you, that you consistently, before you put your name, your signature on anything, you ask these questions. What's the constitutional congruence? Who is the target beneficiary or regulated group? And have you disaggregated them by race, gender, disability? And when you do race, disaggregate race by gender. When we do gender, disaggregate gender by race. Because if you don't do so, Black women with disabilities, LGBTQI women, refugees, and other women who are victims of intersectional inequalities get lost in translation. Fair differentiation where necessary, like in this case, we would like to make fair differentiation when it comes to the state being the one providing resources for access to legal support. Equitable advantage or privilege, make sure that no group gets an inequitable advantage or privilege. And in certain cases, make sure that your laws have some kind of restitutive action where necessary. Lastly, as required by Section 36 of the Constitution, if there's a better way of doing this, of regulating society without harmful consequences, choose that way. And if you can't help it, but choose this particular way, ensure that it comes with mitigation strategies. And lastly, do always make sure that there's meaningful engagement, not only with people like me who have access to information, but also with the ordinary Gogo Dlaminis who will be affected by any of the laws you pass, including this one. Thank you, honorable members, for the privilege to address you. And we thank you and the DHA for undertaking this process.
Thank you very much, Prof, for the presentation. Thanks very much, all the colleagues who have started with us in the morning. Members, I want to invite you to comment or raise questions to all the presenters. If there's any other question or comments. Okay, for now, Honorable
Chairperson, Mr. Ross.
Yeah, so Honorable Ross, the hands that I can see. Honorable Ross, can you proceed?
Thank you, Chair. Chair, if I may, I will just ground my video for the sake of bandwidth.
No, thanks.
Thank you, Chair. First of all, thank you for the comprehensive inputs. I think it really provides a lot of food for thought. So I have a few questions and areas where I believe, it can be a bit of a challenge that we need to consider. I think there's been I'll start with Scalabrini. So you mentioned not detaining children. If children shouldn't be detained. What would then be the mechanism to detain the adult and not detain the infant or child? I'd just like to understand how that would work. And then you also mentioned that we shouldn't detain stateless persons, for example. So there's the issue of Jabu that has been raised. And it's quite a process to verify statelessness. So if somebody had to come and say, I'm undocumented, I'm stateless, how would that process work? Because then if the person is stateless, then you first have to determine whether they're stateless, and then meet the criteria that we are now trying to reach here, where they're not allowed to be detained for a certain amount of time before a hearing. So I'd just like to understand how does that work practically? Because I'm not that familiar with statelessness and how it works and how somebody would claim that they're stateless and then be excused from being detained. From Lawyers for Human Rights, you mentioned that detention must be for a legitimate purpose, and that this bill introduces the interest of justice factors, and it requires precise definition and guidelines. My understanding, and I may be misguided, but Section 60 of the Criminal Procedure Act really talks about interest of justice factors against bail, for example. So, Section 64 talks about, the court may refuse bail if there's a likelihood that the accused will endanger public safety or evade trial or obstruct justice or cause a public disturbance, etc. And then there's also interest of justice factors in favor of bail in Section 69. For example, the strength of the state's case, if the case against them is weak, health conditions, etc. It also covers bail conditions, etc. So if I can just get your understanding of that, if you're saying that those do not cover your sort of interest of justice factors, and what would be then the differences between interest of justice factors that apply to South Africans, where, let's say, you have a bail hearing, and these cases where it needs to be determined whether an undocumented foreign national should continue to be detained or released. Then another general question, and I know that this was mentioned in terms of alternatives to detention would be to release. As a committee, we've been on oversight, and especially at the time of around 2019, 2020, where there were, let's say, so-called refugees outside of the United Nations buildings. Eventually they were housed, and we had a situation during that time where we as a committee found that numerous persons that were issued with an order to leave the country didn't do so. There was no tracking mechanism available to see, did this person indeed come to the border and present this order to leave and leave? So this naturally then, it gives us the impression that there's a tremendous flight risk in general, but it is a generalization. But my question is really around alternatives, and the CSIR is developing a solution around electronic bracelets that can be worn by offenders in the correctional services area, and then tied to an Internet of Things backend under a contract there. So this is for the Human Rights Commission and for anyone that else wants to answer that. Do you see any human rights issues with considering that approach in the future in terms of electronic bracelets as an option where you release somebody with the electronic bracelet, either with an order to leave or until such time as they appear again in court? Thank you, Chair.
Hi, Chair. Chairperson.
Thank you, Honorable Ross. Honorable Mngobeni.
Thank you, Chairperson. Good morning, colleagues and everybody. Thank you for all of your submissions. I just have a couple of questions. The first will go to Lawyers for Human Rights. I just want to understand a couple of things from you. I mean, the amendment bill seeks to strengthen our immigration intentions in this country, particularly as it deals with undocumentation and undocumented persons. And so in our view, you know, we're trying to figure out what is the balance between, you know, the effects of, you know, human rights violations as well as tightening up on our human rights, not human rights, but our immigration processes. You speak about the interest of justice. And I just want to, you know, hear from you in respect to your submission, how you propose the definition be clarified to prevent the arbitrary detention. You also speak about specific wording that should be used. What are you recommending to ensure compliance with constitutional principles? You also speak about some case studies. Can you provide some empirical data where alternatives to detention have been successfully implemented in comparative or comparable jurisdictions? I was not clear on that. You also speak to best practice. Can you provide best practice that South Africa should adopt in implementing alternatives to detention? And then you also speak to South Africa's stance on obligations under the Global Compact for Migration and related treaties. Can you please clarify what you mean by that in terms of your iteration of international law and regional considerations? And then in terms of the CSJ's submission, I was listening to Prof quite intently, and I was wondering in terms of the spirit of our constitutional provisions, particularly with regards to balancing human rights. Of course, the historical injustices, particularly, you know, against Black people who were denied citizenship for the longest time. There has been this issue with regards to the fact that perhaps we need to relook, and that the Constitution does provide sweeping rights, particularly, you know, because it stems from, you know, our stated past. What I want to know from the Prof is that obviously tensions exist between South Africa being able to manage migration. We all know that, you know, while we can be academic around these issues on the ground do, you know, inform us that there has been widespread abuse of the system. And all of these categories of migrants that are in the country, from those who are asylum seekers to those who are economic migrants, you just mentioned stateless individuals, etc. There has been huge abuses of the system, not to mention the corruption that exists. What I want to know from the professor is, do you believe that South African citizens, because you mentioned that the discriminatory, spirit of the bill prioritizes citizens over foreign nationals in terms of their rights. Do you believe that they should be as citizens as they are in other countries over foreign nationals in terms of rights, access to services, and economic opportunities? And how do you balance this with our constitutional commitment to human rights and non-discrimination? Because the reality is that the spirit or the feeling is that foreign nationals, particularly those who are undocumented, and these human rights balances, create enormous tension, and that citizens by nature should be prioritized, particularly because they have been born here. And if the state is doing all that it can to accommodate those who come to our country to seek asylum or opportunity, or any kind of reason why they came here, if they do so legally, what is your view on that? Because, that seems to be sort of a moving target that will never find resolve. I just want to get a sense as to what you would propose in this regard. I think I'll end it there for now, Chair. Thanks.
Thank you, Honorable Ngobeni. Honorable Ngubane.
Thank you, Chair. I think, Chair, while I raise my hand, a lot of items were covered that I wanted to ask by Honorable Ngobeni, especially on the South African Human Rights Commission. That have they looked at, when they're doing their human rights for illegal immigrants, have they looked as well, when they presented this, considered the negative connotation or the crime rate or any negativity caused by illegal immigrants? They need to consider that as well, and on how justice needs to be done as well. When they do this presentation as well, they must consider the human rights as well of South African as well. What I'm trying to do, Chair, somehow, we need to balance our presentation and not make them imbalance and prioritize others and not prioritize South Africans. But most of the things, Chair, have been covered by Honorable Ngobeni and Honorable Ross, especially on alternatives. We need to, if a lot of presentation speaks about alternative, can they give us those examples of alternatives? What are those alternatives so that we know that besides the detention that they said sometimes it poses inhumane on human rights, what are the alternatives that we can do, especially on illegal immigrants? And I think Mr. Ross covered me about the detention of children, that if a parent is detained and that parent has a child, how does that parent going to offer care if they're going to be separated with their child? So, Chair, I think most of the things have been covered, so I won't go venture on all of them. Thank you.
Thank you, Honorable Ngubane. Honorable Mishwa.
Thank you, Chairperson, and good morning to everybody. Thank you for the presentation. My first question, maybe my first two questions will go to Scalabrini. They said Section 34 appears to apply to everyone, inclusive of children under the age of 18. There are children, 16-year-old children, who have larger bodies. And there are over 18s that have smaller bodies. Now, when a person has violated the law, and there is a need for detention, how can officers whose responsibility it is to deal with lawlessness be convinced that the person they are dealing with is underage. The person has a large body, and they say they are underage, but when you look at them, you do not agree with what you hear. What you hear does not confirm what you see with your eyes. So it is a challenge. It is a problem that I would want to know how it is suggested that you need to deal with such a situation. And if it can be proved that a child maybe is around 16, what should be done with the child? Should children who are violent, for example, be let loose to go into the community while they are a danger to a society, and the officer thinks that persons maybe should be deported? First question, what should be done for those under 16, under 18 who are being used by criminals? We know that criminals do use children. Even those who want to do housebreaking, at times they use children to go through the windows where there are burglar bars. So how do we deal with such children? Yeah, that's my first question. But the second one, talking about alternatives to immigration detention, they said a decision to detain must be based on an assessment of the individual's circumstances. I need clarity on this one. How much time do you have to do this assessment? And in the meantime, while you are doing this assessment, where should this person who broke the law be held? Okay, you cannot detain this person, as the suggestion is made, before an assessment is made. So should this person be let go and to continue doing the crimes, or if we have to make a decision based on the assessment of a person's circumstances, what will be happening to the offender at the same time? Lawyers for Human Rights spoke about stateless persons should be protected from arbitrary detention and deportation. If an offender claims they don't have papers, or they've deliberately destroyed their papers, and then they claim that they are stateless, how do you deal with that matter? How do you prove that the person is not stateless, but she's hiding the facts of where they come from and who they are? How do you deal with a person who claims stateless? And if a person is stateless and has committed a crime, what should be done? Can that person be detained because they claim to be stateless? And ultimately, shouldn't that person be deported? There are times, obviously, when people think, sometimes I do think like that myself, that it looks like the rights of offenders at times are more respected, more protected than the rights of the victims. So when a person is a serial offender and they claim statelessness, what should be done? Shouldn't they be detained and deported? And my last question, when it comes to accommodating, we know that accommodation is a problem. Lindela is one of the places that are overflowing. Now, Home Affairs is advised to have a network of open accommodation options. Now, practically, where do you find enough open accommodation options when we have such massive backlog of housing? When you drive around, walk in the street, you see so many homeless people. And when you see these homeless people, you ask questions about them, you'll be told that we don't have accommodation for them. We don't know where to place them. And now a recommendation is made that Home Affairs must compile a network of open accommodation options. Do we have enough of the open accommodation options, or is Home Affairs going to have another burden of doing something that it is not easy to do? Because those who have been on would want a place to stay. And now if it appears that those who break the law are getting preference to law-abiding citizens who have been on the waiting list for more than 20 years, how are we going to resolve this problem in a way that law-abiding citizens are not are not uncomfortable because the others seem to be favored before them? Thank you, Chairperson.
Thank you, Honorable Mishwe. Honorable Manchi.
Thank you. Thank you, Chairperson. We welcome the presentations. I've got just few of them. If a person who is said to be stateless or undocumented be free to be loitering in any country as she or he is pleased, for how long should be this person or person be a free rider? Because most of them, they don't want to go back to their own place of birth. There is no person without a place of birth or a country of birth. For an example, if they can go back to their own place of birth, they should get their documents or they can be documented. We've been in Lindela, where these people told us clearly that they don't want to go back. They don't want to be sent back to their own countries due to the things that they did from their places of birth. Others, they killed people. They've done nasty things. They told us in Lindela. Let me come to the child. For the child not to be detained, if that child is still attached to the mother is the one and the child is at the back of the mother. And seemingly, Chairperson, lastly, it seems as if the foreigners are given, listening from this presentation, the foreigners are given a lot of rights than the South African citizens. The other thing is that comparison. When you are comparing the citizen, human right, and the foreigners' right, and the citizens, this of the South Africa or the South African citizens, this is their own place. This is their own country. They've got to enjoy their rights. It seems now we are trying to balance. How can you balance the person in the country which is not his own, and you compare that to the person who is the home, which is in his home? It seems as if the rights, this issue of human rights, it leaves us thinking otherwise, that if we are here in our country, there are people from other countries who have got to share the rights, you have got to share the enjoyment. So, Chairperson, that is my own contribution and some confusion, especially when it comes to the rights. Thank you.
Thank you, Honorable Manchi. Honorable Mdisa.
Thank you very much. I think I'm extensively covered by members. They've raised. One can just make one point with regard to the lawyers for human rights on the matter that they raised on the alternative to detention. Taking into consideration that the country is already incurring a lot of cost of funds, money-wise, with regard to detaining illegal foreigners who are in our country. And that money is being incurred by South African taxpayers. My question I would want to pose to the human rights lawyers that whether they have thought about the financial implications of the alternatives to detention and how they think the government should finance those measures that they have proposed to us, taking into consideration that most of these, actually these illegal foreigners that are in the soil, they don't contribute to the very same tax, but they want to benefit from the social benefits that the South African government provides to its people. But including the fact that when they're in detention, the government still incur a cost to house them, to ensure that they have clothing, to ensure that they eat. Now, have the human rights really thought about the burden that they put on the South African government, and where and how do they think the government should be able to finance those measures that they've proposed? Thank you, Chair.
Thank you, Honorable Mutisimza. Members, I'm going to request the presenters to respond to all the issues that have been raised. We'll also request the Department of Home Affairs to prepare a comprehensive response, not today in this meeting, once we have concluded the oral submissions in a later date. Can I start with the Scalabrini?
Thank you very much, Chairperson and honorable members. Perhaps to begin with the first question asked with respect to children. So the short answer is that the best and what would be in the best interest of the child would be to issue the family with a notice to depart. So where there is a family who is together and their children concerned, then the individual to leave the country should be issued with a notice to depart, so the family unit is protected and preserved. There are numerous instances in practice, and South Africa did adopt many times in the past the process of issuing notices to depart, and people left and departed. Sometimes they were asked to produce copies of their ticket, either bus ticket, train ticket, plane ticket. They produced them and they departed. If the parent has not departed, or it's not appropriate in the circumstances, perhaps somebody who was given an order to depart and didn't depart in the past, then the family may be separated and the children can be placed with other relatives or family members while the parent is detained. Alternatively, they may be placed in terms of the child and youth care centers. You know, there are different placement options available for children in instances where the parent is detained. And that would be probably the best alternative if one doesn't give a notice to depart to the family, so that you're retaining the family unit. And it's also just really important to note, and I think that I can connect this to the other question when it talks about, you know, what happens with a child who is involved in terms of criminal activity or otherwise. And, you know, there are some older but yet under the age of 18, but more mature children. We're talking specifically about civil detention in terms of civil law. This is not in terms of criminal law when somebody is detained under Section 34. It's dealt with by civil law magistrates. And it's not a crime in terms of what you're talking about, sort of very serious like physical crimes, assault, etc. The criminal justice system must still run its course. And if somebody is involved in criminal activity, then regardless of the age, there are mechanisms already in place to deal with that. What our submissions are saying is that when it comes to civil detention for deportation dealt with by civil magistrates, where somebody is detained because by merit of being a foreign national, it makes no sense in terms of the best interest of the child, in terms of the moratorium on detention of children for deportation, to detain a child. Even if that child is related, a family member is detained, then that child must be put in alternative care or placement pending deportation. And then when it comes to stateless persons, I think that there needs to be a good understanding of who a stateless person is. A stateless person is a person that no country recognizes their nationality. It's very specific. If And in fact, even South African law in terms of Citizenship Act Section 2.2 recognizes that if somebody is born here and no country takes responsibility for that national, then the South African government itself must take responsibility for a child born and registered here to grant them citizenship. To avoid the risk of statelessness. Stateless individuals are a particularly vulnerable group. So in essence, what should happen with a stateless person is that they should go to, it's within the mandate of the UNHCR, it's within the mandate of UNHCR partners, you know, the government of South Africa, Department of Social Development, Department of Home Affairs should make its level best efforts to establish the nationality of the person, whether it's South African nationality, which it might be in a lot of cases, and we talked about Honorable Professor Madonsela spoke about Jabu. You have a lot of cases where you have South Africans who don't have IDs, but they are South African nationals, and actually awarding them South African nationality, or alternatively establishing the nationality of another country. And lastly, just to mention that a stateless person in terms of vulnerability is considered somebody, so if somebody is stateless, that person does not have the right to rights. So that emphasizes the intensity of their vulnerability. Then when it comes to the alternatives to detention, and I'm sure colleagues from Royal Human Rights will add to it, but we talked about there are countless cases in practice we encounter where families are able, willing to pay the costs of return to the country, therefore wouldn't be at the cost of the state. That's an alternative to detention. There are numerous examples, and the department would readily have an approach of ordering a person to leave the country within 14 days or 30 days, and people would leave the country. But that has been, by and large, halted and result in the detention at the cost to the state. So that's an alternative to detention, is to give a notice to depart, and you can advise or require a person to come to the immigration officials and report once a week or once every 2 weeks to ensure that the person departs and see what efforts they've made towards departure. You can make a provision, you know, there can be case management to address and assist. There can be the two strikes principle, and this is really important. As I say, in cases where alternatives are adopted, it saves the country so much money, because almost 80% of individuals depart from the country, 78% of individuals depart from the country, and only your 22% remaining are those that you might need to detain because they don't depart through the adoption of alternatives. The issuance of some kind of surety or bail, so that is forfeited if somebody doesn't depart the country, is a very effective mechanism. There was talking about electronic tagging. It is an option. At least it means that an individual isn't in detention pending deportation. And most crucially, community care schemes, where the community from which the migrant is from, residing in South Africa, halfway houses, these residential alternatives are really low cost and much less expensive than holding somebody in, let's say, Lindela or in police cells, which is where a lot of people are held at the moment. So that's a number of the alternatives to detention. I think those are the questions that were referred to the Scalabrini Center. Thank you very much.
Thank you very much. Lawyers for Human Rights.
Thank you very much, Honorable Chair. I will begin and then hand over to my colleague to deal with the ADT questions. With regards to Honorable Ross's question pertinent to the interest of justice criterion, it is very important to point out the fact that Section 34 detentions are an administrative process, and they are not a criminal offense to be clear. So they are not dealt with in terms of the Criminal Procedure Act. And while Section 60 of the Criminal Procedure Act does set out in great detail when the interest of justice would permit somebody to be released, that would not be applicable when somebody is detained in terms of Section 34. As my colleague James Chapman clearly articulated, that these matters are dealt with by a civil magistrate. And therefore, it is imperative that it is clearly stated out in this proposed bill what interest of justice in administrative detention would actually mean. It can be borrowed from the Criminal Procedure Act in determining what those mean. It can be borrowed from existing jurisprudence as to what that exactly means. But what we are calling for is that it needs to be explicitly stated out, as it is currently stated out in the Criminal Procedure Act, and that this particular bill would be beneficial to having explicit provisions. And to answer, or also to add the fact that legal aid does not deal with these kind of matters. So adding to the fact that there would be a requirement for a person to be actually given the possibility of having legal representation, which currently is not the practice, where a lot of people are unable to actually get legal representation in Section 34 hearings. To answer to Honorable Ngobeni's question with regards to our proposed definition, we set out our proposed definition in pages 39 and 40 of our written submissions. It is quite an extensive recommendation, but I will read briefly. We set out that the interest of justice should mean the overall public good, balanced against the individual rights and circumstances of the person concerned. It should be determined by considering the following factors: what the person's current documentation status is, whether they have been given an opportunity to regularize their stay in the Republic. In this regard, special consideration must be given if they are an asylum seeker, refugee, or a stateless person. The specific circumstances of the individual, including their familial situation, their health condition, their age, and any other vulnerabilities, the least restrictive measure necessary to achieve the immigration objective, taking into account alternative measures such as reporting conditions, the protection of the individual's rights and dignity, including but not limited to access to legal counsel, healthcare, and basic necessities, the human rights obligations owed by the Republic, and consideration whether or not this person has been detained before for Section 34 purposes. And our biggest concern with regards to this determination of interest of justice is the fact that this needs to be considered by an immigration official when they encounter such a migrant. And it is particularly empirical that such immigration official is trained and on the sensitivities of the different factors that might be applied, as mentioned by Prof. Madonsela, that a one-size-fits-all criterion cannot apply because there are different considerations that need to be taken when dealing with different people. Thank you so much, honorable members. I will hand on now to my colleague Zeketelo to deal with the 8 alternatives to detention.
Thank you, Chair. Thank you, honorable members, for the questions. I think I'll start on the question of Honorable Ross with regards to ankle monitoring. You will see that in our recommendations, we did not particularly include the electronic monitoring tool. However, we do take into account that it has been used globally, increasingly so as a means to alternative to detention and migration control. The reason that we may not have been ready to make that recommendations is because of precisely what you're saying, because of the implied sort of muddied waters of its implications. We think that amongst other rights that you'd have to consider with regards to electronic monitoring is the issue of violations to privacy, but also if we look at it in the context of South Africa, you might even find that there's increased risk of stigmatization, but also as my colleague was stating, the issue of immigration detention is an administrative one. It's not a criminal procedure in a sense that you would have it in the Criminal Procedure Act, but also where we have seen the usage of the electronic monitoring devices, we have seen, like I said, it would further, condone the stigmatization of migrants because they basically be treated like criminals when it's a person, for instance, a stateless person, an asylum seeker who is within the system or continuously trying to regularize their stay in their country. But it also has a lot of data and security risks, because it has the potential to expand beyond migration control. So I think if the department were to even consider the issue of electronic monitoring, they would have to consider other rights that might be, practically implicated within that process. But also, Honorable Ngobeni, I think, raised the question of empirical research or that we use to compare to other jurisdictions. I think that we made a reference to various jurisdictions in our submissions from page 25, particularly from paragraph 55. We looked at the empirical research of Canada, for instance, where there is a strong usage of community case management that is showing a 95% compliance rate. This means that, we, like I said, again, it's an administrative process. So when you use, less restrictive measures to migration control, we see that from our research that it increases the compliance rate for people to sort of, abide by the immigration protocols, whether through application or at a point where there is no migration that can be offered to that person to regularize their stay in the country. I think also when it comes to one honorable member raised an issue of open accommodation centers. I think that when we look in comparison to the costs, I think if the honorable members requires us to do so, we can provide the numbers of the cost of detention in South Africa at present. And we believe that if asylum seeking, as much as it's a protection based concept, but it also, with the existing framework of the Refugee Act, for an example, it allows or even states that asylum seekers and the refugees should be given an opportunity to integrate into our society and contribute positively into their host countries. And I believe that if we saying that we recommend an alternative like open accommodation centers where checking in and all of this stuff, it increases the compliance rates, even when now the person would be aware that your application has reached this specific stage and they can be susceptible then to voluntary repatriation. I think our submissions are based really around looking at the cost of detention, of immigration detention, and what it is currently costing South Africa as opposed to alternatives that are less infringing, as many detention contexts would be, and with the aim to sort of increase that compliance rate. I think that if we can provide that empirical data. And another question was about whether there are any best practices that we can suggest, particularly based on the Global Compact on Migration. I think the Global Compact on Migration provides several best practices that South Africa can incorporate into the framework of ATDs. But I think the most relevant one that we pointed out is centered around Objective 13. That already we do as South Africa have the framework that is based on the respect for dignity and fundamental freedoms. I think the point that we are making, or what we are taking away from that particular framework, is that detention should never be used as a form of punishment or deterrent, because in its essence, administrative immigration detention is an administrative process, and not a criminal one. Like James pointed out earlier, if you find that a person who is undocumented or is seeking asylum, but they have committed a crime, then the Criminal Procedure Act will, of course, take its course. It should not be correlated with one with the other. But also there was a question of assessment of individual circumstances. And then when we say that, what should happen in the meantime? We think that while individual circumstances are being assessed, even the bill itself calls for a more preliminary approach to see whether the detention is possible or necessary in particular circumstances. In making that recommendation, we are following the language of the bill, which seeks to also, ensure that there is compliance with human rights standard, but also prevent unnecessary deprivation of liberty. We have another question that referred to what are these specific alternatives to detention that we are speaking about. If you look at our jurisprudence, but also if we look at the submissions that we made in the empirical research that we refer to, we picked out specific alternatives that we believe would be possible in the South African context, some of which are already implied in the legislation, particularly when it comes to the discretion, whether you release a person with an order to depart, to say they must leave within 14 days. And for that to happen, you would have a person would provide some sort of traveling documents, for an example, that they would leave on such and such particular date, but they are being given an opportunity to sort of wrap up their affairs in the country. We are not saying that we are bringing anything inherently new, but rather the alternatives are meant as on the practicality level. And when we did the research on the cost analysis of detention, the end is simply just not justifying the means. So the temporary release, for instance, or reporting obligations, or placement in open reception centers, or even if you want to bring out the framework of the bail conditions, which can never be the case, or even if it were, it can be a situation where we are saying that inquiry should be based temporarily with the case to have sort of a case management and increase compliance, in that a person is to know that they're supposed to either biometrically or in person check in while their migration status is being determined. With regards to the costs, I think there is a lot of questions also implied as to whether now Home Affairs must bear the burden of these alternatives. While we can say that implementing alternative to detention is would be a new territory, insofar as there is no way right now in the framework where South Africa can tangibly determine the cost, but it is far more, the research that is available from other jurisdictions, it shows that it's far more cost effective in the long run compared to maintaining immigration detention centers. because again, the alternatives that we have suggested, they clearly show that Home Affairs does not have to carry that full financial burden by itself. It's going to require a cost sharing and funding strategies that can be implemented amongst its stakeholders. I don't know if that answers a lot of questions, but also the benefits that we want to also point out in these, also from a preliminary administrative level, is that it's going to surely place a lesser burden in courts if our immigration officials and other security cluster personnel are equipped with the right tools and the right framework within the bill to sort of critically analyze whether it would be in the interest of justice to subject whatever person into alternatives to detention. So it lessens the burdens of the courts, but it also prevents now overcrowding in detention centers, which will, again, when we're doing the cost analysis, it would significantly reduce infrastructure costs, but also looking at it from the gaze that it wants to sort of foster the idea that is already existing in our framework, not only in terms of the Bill of Rights, but also in terms of being able to, get rid of all these backlogs that are within Home Affairs, whether that comes in a form of the encouragement of seeing the process through and partaking, with voluntary returns, or in a matter of where you're looking at it practically, that it would reduce forced deportation expenses and the turnaround of the same people being detained for the same administrative processes without any, finality to the processes. I think I'll stop there for now. Chair, thank you.
Thank you very much, Prof.
Thank you once again, Chair, for the privilege to address honorable members. Although all of the eloquent questions and comments from honorable members had implications for my presentation, in the interest of time, I will only address myself to Honorable Machi and Honorable Ngobeni. Honorable Machi, I think you've already been answered, ma'am, insofar as the purpose of the Immigration Act, which already exists, is to prevent unregulated immigration. And if people are detained, they're detained with a view to assessing their immigration status. And if the immigration officer concludes that they shouldn't be in the country, he or she is empowered to deport them. And I think colleagues then are saying that might not be the answer, particularly when you're still assessing a person's status. Let's take again, going back to the narrative of Jabu. Jabu is a student who's doing matric and somehow bumps into immigration officers and they ask for documentation and Jabu doesn't have documentation, and immigration officers look around, they find that there's no registration of birth, there's no ID, and they determine that Jabu needs to be sent away. So in that process where Jabu is still explaining her situation, possibly an alternative could be found in that they could just be left alone until such time that the full process has been sorted out. Of course, if the person is arrested for criminal processes, then the Immigration Act is not the main instrument in that regard. But thank you for asking that question. Then, Honorable Machi, the other question you asked was, why should South Africans have the same rights as foreigners, given the fact that foreigners also have rights in their own country? That's a fair question. That takes us to the purpose of this amendment. It's a very brief amendment, the 2024 amendment to an existing Immigration Act. So the amendment, it's not me who is saying foreigners should be treated the same as locals. That's what Home Affairs was ordered by the court to do, or you, honorable members, were ordered to do. The amendment that we're talking about was ordered by the Constitutional Court in 2 human rights cases. And the challenge to the existing Immigration Act was that Section 34, which currently provides for the detention, assessment, and deportation of illegal foreigners, did not provide the same procedural safeguards, the procedural justice safeguards that are provided for all in Section 35 of the Constitution and Section 12 of the Constitution. So that's what the court had to answer. Does Section 12 of the Constitution exclude foreigners? Does Section 34 of the Constitution exclude foreigners relating to security of the person and due process? So that question was answered by the Constitutional Court, that these apply to everyone. And you, honorable members, in the draft act have complied with that. So there's no issue now about these applying differently to foreigners and to locals. What is at issue that we are bringing to the party is the question of balancing, which takes us to the question asked by Honorable Ngobeni. Honorable Ngobeni saying, yes, we are enjoined by our Constitution to govern, to subject our governance to a human rights lens. And our Constitutional Court has called it transformative constitutionalism, where everything has to be looked at through the lens of the Constitution. And our Constitution asks you, me, and everyone in this country to ensure that our actions yield the establishment of a society that is based on democratic values, social justice, and fundamental human rights. We therefore don't have an option when it comes to human rights. It's there in the preamble, and Grootboom, the case of Grootboom, reminded us of that this was the obligation we undertook to establish a human rights-based society. Grootboom also says we chose to establish a social justice-based society, which is where we come from. But it does, Honorable Ngobeni, as you have correctly pointed out, create a tension between protecting citizens and providing these benefits, whether they are to refugees or to foreigners, or these benefits might also be restitutive measures to locals in the country. So there does seem to be a tension in the Constitution between protecting existing rights and extending rights to others. I always refer to this as a tension of protect and provide, which Reverend Mesho might understand coming from a religious perspective. And in that regard, Reverend Mesho, just my condolences to you. So the Constitutional Court has given you an answer on how do you do this balancing. And it talks about using the Ubuntu value system, where you look at the equal worth of every individual, and you look at the interests of society, interests of the environment, interests of future generations. And what does it mean in this regard? With these detentions, from our side, we've asked very little from you. We've just asked that the Section 1A that is going to now amend the existing section 34 be amended to make explicit the requirement of legal assistance, and also to clarify very briefly what the interests of justice will be, and we gave you ideas of what will those be. Lastly, honorable members, this bill does not regulate foreigners. It regulates suspected foreigners, which takes us to the legend of Jabu, that the immigration officer could end up with any person who is a foreigner or not a foreigner, a suspected foreigner. And it's not just those children of parents who came to the country unlawfully during apartheid. And I urge you to look into those children as well. Some of them are in their 30s today, and they've never been to the country. The Act talks about returning them to where they came from. And Honorable Machi says they should be returned to where they come from. Many of them have never been anywhere. They've only known this country. So that's a story for another time. What we're talking about is just let's comply with the Constitutional Court injunction, which is amend Section 34 to be aligned with constitutionally protected rights. And then on our side, we said, in so doing, understand that one size does not fit all. Even though you say there will be judicial review in 48 hours, since others do not have money for lawyers, make provision for that kind of assistance. And that person could well be Jabu, but even if it's not Jabu, even if it's a real foreigner, everyone deserves justice, no matter who they are. It could be a pregnant woman, it could be anybody. So, honorable members, we will review what you have asked of us as a team at the Center for Social Justice. I see that my colleagues are attending remotely this briefing, who assisted me with the presentation, Themba Seyisi, and I prepared the presentation together with Stefan Vaughan, and Dr. Marna Lawrence was also one of the presenters at the event. So we will look at this and make a further submission. At the end of the day, we just want to thank you that at least on the face of it, we have complied with the injunction from the Lawyers for Human Rights cases, but we want you to substantively comply to make sure that the injunction by the president that says, let's build a South Africa that works for all, is really an injunction that is responded to positively in everything that we do, including lawmaking. Thank you, sir. Thank you, honorable members.
Thank you very much, Prof. and all Scalabrini and the Lawyer for Human Rights. We'll take the last items or stakeholders. And as we have cautioned in our opening that we'll continue if we don't finish with our colleagues meeting. The first items will be this. Can we then invite the other colleagues or stakeholders to present?
Chair.
Yes, Mr. Martin.
Yes, if we can call the ANC.
Thank you very much. Are they in attendance?
Yeah, Ms. Phoebe is in the meeting. Let's see if she was kicked out. She is in the meeting, Chairperson.
Thank you very much.
Okay, proceed.
Yes.
Good morning, Chairperson, honorable members, and thank you very much for this opportunity. Let me just get my presentation. Okay. Once again, thank you very much for this opportunity to make this presentation to the committee on a matter that's very important. just to say that in our view, and I think the submissions, both written and oral, that we heard today, indicate the importance of this question of migration, that it's part of human reality. It impacts on receiving countries in both negative and positive ways. And South Africa, in an African and also global context, is a receiving country, although of course we also contribute towards migrants in the world. That some of the negatives include social strife, when citizens of a country feel that their rights and living standards are being impacted on, and there is research pointing to that that's true or not true. But I'm not going into that. There's also positives in terms of migration, the extent to which migration can lead to a brain and entrepreneurial gain for a country. And that is why our Immigration Act at the moment provide for both trying to prevent illegal migration, but on the other hand also allow for skills, attracting scarce skills. Over the last 30 years, we've seen waves of migration as the country had opened its borders and adopted without reservation the African Union and the United Nations protocols on migration and refugees. And the draft white paper, in fact, speaks to us and argue for that we need to review this and look at there may be certain areas where we need reservation. The third issue in terms of the background is that over the last 30 years, given the need to immediately address the apartheid backlog in terms of housing, healthcare, social security, infrastructure, water, the capacity to deal with migrations, including refugees, asylum seekers, and economic migrants, have been severely lacking. And I think that the Department of Home Affairs admits that there are serious challenges in terms of how these matters have been dealt with in the form of backlogs, etc. And for example, the fact that only in October 2023, we launched a dedicated border management authority to tackle illegal migration and protect our borders. What we therefore have to do, and I think that Prof. Madonsela referred to it, to find the delicate balance between our national development imperatives and the human rights ethos of the Constitution, as well as being a good global citizen that abide by international law. And I think that's what we've been struggling with, and hence we see the jurisprudence around those issues. That our rate of migration and the measurement used by foreign-born persons according to the 2022 census, and there's some questions about it, at the low end is about 3% of our national population, although others places it as high as 4.8%, Hirsch in 2024, and the IMO places it at 5% in 2024, which is above the global average. So whether you use the low estimate of our census or the highest or higher ones of the IMO, this is part of our reality. A key challenge in our migration policy over the last 30 years has been the increased number of undocumented illegal migrants, which is illegal in both in terms of the Constitution and the law. You can't just rock up in the country, apply for a tourist visa, and then decide to stay on without attempting to legalize your stay in the country. Every single country across the world has laws that govern how people stay in the country. Now, the negative effect in South African context include the pressures on the South African social wage, particularly with regards to education and health systems, but also increasingly with regards to social security as well as settlements, and with settlements, not just housing, but also access to water, sanitation, electricity, etc. The question about the competitions for jobs in sectors such as hospitalities, agriculture, domestic work, and so forth. And the resultant push to the bottom in those sectors, because these workers are vulnerable and whereas South African workers are unionized, have the rights, know their rights with regards to minimum wage, etc., etc. You find these challenges. And then, of course, as we've recently say, competition in the informal economy in townships and villages, as well as the issue of illegal mining. And then, of course, the challenge that's been identified of fraud, inefficiencies, and corruption in the system. And we therefore, at a general level, welcome the major review that's taking place and started to look at how do we look at our immigration policies, as well as the approach to say that we need to consolidate citizenship, immigration, and refugee laws and policies in one policy framework and therefore laws in order to tackle the contradictions in the system. We also support the strengthening the capacity in home affairs, including the integrated ICT systems, the resourcing of the BMA, as well as ongoing efforts to root out corruption in the system. However, we're dealing with the specifics of the Immigration Amendment Act, and our view is that the issues that's been raised in the summarized written submissions, as well as the oral submissions, a lot of them tend to deal with a broader context of immigration, but that the purpose of this amendment is really to act on the instruction from the Constitutional Court in the two judgments that's referred to. Just to say that the Immigration Act, according to the South African Human Rights Commission, say that it creates different pathways for regular migration, as well as ensure access to justice. However, that the primary function is the prevention of irregular migration and the promotion of skilled labor migration. And how do we then make sure that we achieve these objectives? I'm not going to go into the background of this issue, but just to say that, acknowledging the cases that have given rise to this amendment, the delays, which was really unfortunate, and therefore the Concord judgments which required the Parliament to address the issues, the section in the law that's been declared unconstitutional and invalid, including the obligation of the immigration officer to inform arrested foreign nationals of the right and to review, if in the interest of justice, whether the person should be released, as well as the right to impose conditions. The second part of what it needed to address is that if not released by the immigration officer, the obligation for the person to appear before court within 48 hours, and then with the possibility of extension to 30 days. And again, the interest of justice requirement, therefore. And the overall implications of this instruction of by the Constitutional Court is that no person can be deported without, unless they found at the borders, and there's specific laws dealing with that, can be deported without access to the necessary judicial review and those processes. And I think that has been the approach that's been followed by the department responsible for the implementation. Just to remind ourselves as well, the implication of this amendment that again, as the South African Human Rights in that document that I referred to said, the objective of the original section is to deport undocumented illegal foreign nationals without prosecution. That what the amendment does is to audit, as ordered by the Concord, to provide procedural justice safeguards in the form that it has to go to court, that the immigration officer has to show that they have informed persons of their rights, as well as applied their mind in the interest of justice. The argument that's been made is that the shift to all foreign nationals, and we think that it is addressed by the two steps that's suggested in the amendments. Firstly, that the immigration officer has to apply their minds There's reference in the Act to a form that they must fill in if there's conditions in terms of to release a person. If they keep them detained, there is then the option of not the option, it's in fact obligatory that the court must then review it. We hear the issue that's been raised about the difficulty of the interest of justice test by both the immigration officer and court, and the committee may want to consider to look at some more explicit provision in the Act. So what are our recommendations? Apologies. So we're making 4 recommendations. The first one is that Parliament has to find this specific matter, and that we shouldn't try to expand the scope of what the Concord has ordered Parliament to do, that we need to deal with a specific remedy that's required by the Constitutional Court, which is the obligations on the immigration officers on the one hand, and then the fact that there should be judicial review and oversight, and that we shouldn't go beyond that. That is the look at our broader approach towards immigration policies, including the question about alternative accommodation, etc., should be part of the broader review of our approach towards migration, which is urgent. Secondly, that given the decree about the content of the amendment by the Concord, there were fairly specific scopes that were given by the Constitutional Court. It does give scope for, the scope for changes are therefore limited in terms of what the amendment bill should be doing. The third issue is that we want the committee to note the concern about the implication of the amendment on the criminal justice system in general. That now, given the fact that we're placing an additional burden on the criminal justice system to hear that, and I hear other colleagues talk about setting up special migration courts. I think that all of those things need to be costed to see whether it is affordable. That Parliament through the committee need to ensure that this matter is monitored to look at the impact on the criminal justice system, but I also think on the capacity of Home Affairs. And then the fourth issue is that our plea is that the committee and Parliament must expedite, and I see that the department and the ministry is also present here, that we must expedite the process of the immigration, citizenship and review white paper and law process, so that as a country we can have a debate about all of these issues, very important, that were raised by presentations today. For example, the balance between our national development imperatives and our human rights ethos, the broader question about what is the type of immigration that South Africa can afford in the context, not just on a cost basis, but also in the context of national cohesion, given the history and where we come from, the contribution of migrant labor to the development of our country, etc., etc. We need to have those debates. The questions about what is the best way to deal with immigration, given our experience of the last 30 years and the experience from other countries. We really call on the committee to make sure that, working together with the department and the ministry, that we do expedite the comprehensive review of our approach towards immigration, the integration with issues of citizenship and refugees, so that at the end of the day we can have this conversation. But our plea is that we should not try and broaden the scope of this Amendment Act, given the fact that it's already long outstanding following the order by the Constitutional Court, and therefore we support the amendment. and that the kind of concerns that's been raised could be addressed by regulations. Thank you very much, Chairperson.
Thank you very much, Ms. Potgieter, for the presentations. Mr. Matonsi, can we invite another presenter?
Yes, the next presenter is CGE, Chair.
Thank you. Can they proceed?
Right. Good afternoon, honorable members. Am I audible?
Yes, you're audible.
Thank you very much. I'm just going to share my presentation. Okay, is my presentation visible?
Yes, thank you.
Thank you. All right, so good morning, Chairperson, and good morning to the committee members. My name is Bradley Swanepoel. I'm the legal researcher at the CGE, and I'm joined online by our CEO, Dr. Dennis Matatoka, and our acting head of department for the legal department, Mr. Setsu Shupeng. So we did a fairly short submission on the bill, and as a result, my presentation is going to be fairly quick as well. But I'm going to start by just giving a brief introduction of who we are. And the CGE, as you may or may not know, is a Chapter 9 institution. We are established in terms of Section 181 of the Constitution, and our mandate is set out in Section 187 of the Constitution, that mandate being to promote respect for gender equality, as well as protect, develop, and obtain gender equality. And then our powers are further enumerated by the Commission for Gender Equality Act, and Section 11(1)(c) specifically empowers us to evaluate any law proposed by Parliament or any other legislature, and it's that section that we rely on when we send submissions on bills like this one. Okay, so just by way of background, we all know that this bill has come about as a result of the decision of the Constitutional Court and Lawyers for Human Rights, which declared Section 31B and D of the Immigration Act unconstitutional because those sections infringed the right to freedom of security contained in Section 12 of the Constitution, as well as the procedural rights that are afforded to detained persons in terms of Section 35(2) of the Constitution. I would just like to highlight one of the consequences that this judgment had in regard to matters that we saw and complaints that we received relating to GBV victims. So just by way of example, we received a complaint from a particular person who was involved in a relationship with the foreign national. The foreign national was convicted of domestic violence or acts of domestic violence against that complainant and was sentenced to 9 months imprisonment. They were then deemed to be deported and to continue serving their sentence in their home country, and they were released after 2 months from the custody of correctional services into the custody of Home Affairs. But unfortunately, because of the problems that Home Affairs was experiencing as a result of this judgment, that person ended up being released. And after they were released, they continued to harass this complainant and eventually absconded. So I bring this to the attention of this committee not to bemoan, where we are now and what's happened as a result of this judgment, but just to emphasize the urgency and the importance of this bill being finalized, so that it can create a sense of certainty for victims of GBV, who, as is the case with the example that I've given. So our general submissions in the bill, in regard to the bill, we were supportive of the bill for 2 reasons. Firstly, obviously, it's a response to a declaration of invalidity, constitutional invalidity, and any rectification of a constitutionally invalid act we would support. But for the reasons I explained just now, it also brings a lot of certainty and clarification to victims of gender-based violence when the perpetrator is in fact a undocumented migrant. Just in regard to the bill, one of the submissions that we did make was in regard to the language used in the bill, and you will notice from the bill and the act, it refers to illegal foreigners as illegal. So we made the suggestion that because the term illegal carries fairly negative connotations, that there's the potential for stigmatization as a result of that. And we all know the issues of xenophobia and xenophobic attacks that we've had in our country. We made the suggestion that instead of referring to illegal foreigners as illegal in the act, that perhaps it might be more appropriate to refer to them as undocumented persons or undocumented migrants, just as a way of respecting the inherent dignity and using destigmatized language. So Chairperson, that essentially was our submissions. So just in summary then, the CGE is supportive of the amendment bill in its attempts to deal with the Lawyers for Human Rights judgment. We do think the passing of the bill is going to give positive consequences for the victims of GBV for the reasons I've already elaborated, based on what we've observed as happening on the ground as a result of the judgment. But we would just urge that the language in the bill be considered and that the terms like illegal foreigner be changed to undocumented migrant. Okay, thank you, Chairperson, and that concludes my presentation from the CG.
Thank you very much. Thanks a lot for the presentation to the committee. Mr. Matonsi, can you invite the third?
Yes, the next presenter is the Center for Child Law, for the Child Law.
Thank you. Can they proceed?
Thanks, Chair. I will just share my screen just now. Can everyone see my screen?
Yes, you can see it. Thank you.
Okay, thank you very much. Thank you very much. Good day. My name is Fortunate Mungwai from the Center for Child Law. We are based at the University of Pretoria, and we are a child rights organization with a mandate to promote the best interest of children in South Africa. And we do that through research, advocacy, litigation, and education. And we would like to thank the Portfolio Committee for this opportunity to make oral submissions, in addition to the written submissions that we made last year in November. Our submissions will briefly touch on the issues we've raised in our written submissions last year. As a way of introduction, we note that South Africa is basically a favorable, I'm not sure if I'm able to go to my next, okay, not there. As a way of introduction, we note that South Africa is a favorable destination for a wide range of child migrants from SADC countries. And the drivers to such migration are very complex and unique due to their circumstances surrounding the migration. However, regardless of how the child enters the Republic, whether regular or irregular, once they are found to be in the Republic, they must be afforded the protection as this is outlined in the Constitution, as well as the child rights legislation, such as the Children's Act, taken into account against South Africa's international obligation. Most of these children, however, we see that they lack proper documentation, which then make it difficult for the government and other stakeholders to detect, identify, and provide them with care and protection. We note again with great concerns the numbers of queries we have received of many migrant children who are unlawfully arrested, detained, and placed in facilities that are not appropriate for children. This is clearly in conflict of South Africa's national and international obligation in ensuring the advancement and protection of children.
You can move your slides as you input on issue.
Yeah, so it's still within my introduction. Sorry.
Thank you. You can proceed.
Oh, thank you very much. So we see that this unlawful detention of children is clearly in conflict with national and international obligation to ensure the advancements and protection of children's rights to liberty, dignity, as the procedure that is followed is often not too clear. Children, as we see again, they are an afterthought in issues that often concern them, and this leads to legislative framework particularly the Immigration Act, not being too clear when it comes to them. So there is a need for clarity when it comes to issues pertaining to children. CCS, Center for Child Law, again, we wish to reiterate that our submission in no way support irregular migration. However, when it comes to children concerned and considered to be irregular migrants, the obligation is to protect their rights, and that should be the starting point of our country without arbitrarily detaining them. In our submission, again, we have highlighted that cases of migrant children are very unique and require special consideration. And we proposed that there should be an inclusion of key terms that will avoid confusion by officials when they are dealing with children who are believed to fall under Section 34(1) of the Immigration Act. In the interest of time, I think we will not go through this definition, but we note that their importance as a starting point to understand categories of children and how to approach these cases. And my colleague from Scalabrini, I think he had made mention of one of the definition of what a stateless person is. So we believe that these very definitions are very important to assist when one is come into contact with a child who's believed to be a migrant child. Again, in our submission, it was very important that we also address international obligation relating to children's rights, which South Africa is signatory to, and particularly the United Convention on the Rights of a Child. So the convention, in its sense, outlined the 4 important core principles, and this principles is the non-discrimination, best interest of the child, the survival and development of a child, as well as the view of the child. Again, Article 22 of this very convention outlined that the state must protect and assist irregular migrants and also assist in issues of identifying family or reunifying them with their families. Again, we see in Article 37B, which states that no child should be deprived of their liberty unlawfully, and arrest should be a measure of last resort. This is important to consider to ensure that the bill aligns with the constitutional principles and also take into account international obligation. Furthermore, our constitution provides that the protection of children, provide for the protection of all children, regardless of documentation status in the Republic. And while the bill seeks to align itself with the constitutional principle, we wish to remind the committee that Section 28 provides for the rights of all children. Particularly, we see in Section 28, subsection 1G, which provides that the detention should be a measure of last resort. Again, Section 28(1)H confirms that the child has a right to legal representation. So we propose that Section 34 of the Immigration Act must be read in line with Section 28 of the Constitution, taking into account appropriate measures when dealing with children who are alleged to be irregular migrants in the Republic. Again, we wish to reiterate that the best interest of the child should also be taken into consideration when dealing with matters relating to them. The Children's Act, while the Act empowers the officials to arrest and detain illegal immigrants for up to 48 hours, we emphasize that in the cases where children are concerned, there should be a clear process followed in terms of the Children's Act. And we see in the Children's Act that has been amended where under Section 115, 1J provides that unaccompanied migrant from another country are children in need of care and protection. So this clearly again indicates that there should not be any arrest or unlawful detention of children alleged to be irregular migrants due to lack of documentation. There is no provision in the Immigration Act indicating how children are dealt with. So we propose that the Children's Act must be taken into consideration when we are dealing with the issues of children. And again, we have proposed that there is a guideline by the Department of Social Development which deals with unaccompanied and separated migrant children. And this particular guideline outlines the roles and responsibilities of all stakeholders. And this includes the Department of Home Affairs, the Department of Social Development, South African Police Services, and it clearly outline the process that should be followed when they come into contact with a child who's believed to be a migrant child. And we do highlight this comprehensively in our submission, and we hope that it will be of great assist in that regard. Children again who are stateless. And the definition of stateless was already defined by my colleague from Scalabrini. So children who are stateless or at risk of being stateless, their deportation is often very impossible to a certain extent. And we propose that other alternative pathways to citizenship be considered rather than detention due to lack of documentation. And in our submission, in our written submission, we go into details in regard to how that can be done in that regard. Again, we further propose that the committee take into account the case of the Center for Child Law versus the Minister of Home Affairs. So this is the Lindela case that took place in 2005, where children who were detained in Lindela were subject to deportation, but there was an agent application that was made by the Center for Child Law to stop the children from, to stop the department from detaining the children at Lindela. And this case also highlights the importance of how migrant children must be dealt with, particularly in relation to due process and ensuring access to justice, which must be child-centered. And in our submission, again, we go into detail with regard to how this case was addressed. And also, again, in the interest of time, we will not go into detail pertaining to this case. However, maybe during the Q&A, I may be able to address what the purpose of the case law was all about. However, what is important to note is that the importance of it was due to due process and making sure that when the matter is before the Children's Court inquiry, there needs to be an inquiry before a child can be deported back to their country of origin, if so alleged. And again, in our submission, we highlighted the issue of age estimation. So often children are detained and they are deemed to be an adults without any form of valid proof to prove that that is an adult when they are placed in prisons or they are placed in centers that are mainly meant for adults. So we propose that there should be a need for an age estimation that it's taken place, and a child again then should be deemed to be a child until proven otherwise, and that can be done by an age estimation. So this process obviously must be scientific, fair, and sensitive, respecting the human dignity and ensuring that uncertainties favors the child treatment as such. So we propose that when a child is therefore now alleged to be an adult, an age assessment is done, and a social worker in that regard is involved to assist in that process to ensure that the dignity of the child is taken into consideration. And again, in relation to our recommendations pertaining to the provisions of the bill, we had proposed that there should be an insertion of section 34, 1 capital B subsection A, as well as section 34, 1 capital BB, which will outline in detail the process to be followed for children who are alleged to be in the Republic irregularly. In this particular section, section 34, 1 capital B subsection A will be read as follows. Where the alleged illegal foreigner is a child, they must not be detained, but must be dealt with as a child in need of care and protection in terms of section 151J of the Children's Act of 2005. Further, section 34, 1 capital B subsection B must be read as follows. Where the alleged illegal foreigner alleges that they are a child and no reasonable alternative confirmation of the person's age is available, then the person must be referred for an age assessment in terms of section 40 subsection 2 of the Children's Act of 2005. And that will be all from Center for Child Law's side. And we thank you very much for this opportunity to make oral submission. Thank you very much.
Thanks very much for the submissions. We'll now invite the next, Mr. Matwensi.
The next one is UNHCR.
Thank you. Can they proceed?
Okay. Good afternoon, everyone. I just wanted to confirm that I'm audible.
Yes, you're audible. Presentation is. Thank you. Can proceed.
Thank you so much, Honorable Chairperson. Thanks, MPs. Thanks everyone for the opportunity once again to invite UNHCR to these deliberations in the portfolio Committee on Home Affairs on the Immigration Amendment Act. It's always an honor and a pleasure for us to be engaged in these discussions. From UNHCR, well, we've been engaging in similar sessions in the past with the portfolio Committee on Home Affairs. We are the United Nations High Commissioner for Refugees, the agency mandated by the General Assembly to support governments, provide international protection to refugees, statelessness, and other groups of concern. And we do it through different means. So this is one of them. We can move on with the content. We're going to be brief and stick to the 10 minutes avail. We wanted to briefly explain what is our interest in this submission. Obviously, there is a number of matters related to asylum seekers and refugees. We have been seeing already previous presenters touching on how this piece of legislation touch on asylum seekers and refugees. And this is obviously what motivates our submission. And this is going to be today a very brief summary of the submission that we made officially. We are, as I mentioned before, mandated to provide solutions and protection for persons in need of international protection. These are asylum seekers and refugees. Also statelessness. Stateless persons. We already hear other presenters describing what the stateless is, a person who is not considered as a national by any national legislation. We've been engaging on different responses to displacement, and that includes also responses to what we call mixed movements, which are groups of both asylum seekers and refugees and economic migrants. In our mandate and core activities for us in South Africa are to ensure that the right to seek asylum and the principle of non-refoulement are enshrined and duly protected. And we made reference to this in our submission to this particular piece of legislation. We also, in our submission, devoted quite some space to alternatives to detention. This has also been touched upon by previous presenters. So we will not dwell too much into that, but we wanted to take the opportunity to flag that we also shared with the Portfolio Committee our detention guidelines, which include a number of alternatives to detention. Some of them were mentioned today here, but it ranges from registration, bail, community release schemes, reporting conditions, electronic tagging, home curfew. Those are points that we cover in our detention guidelines that were also shared with the committee. So in terms of the key sort of provisions, in addition to ensure that the right to seek asylum and the prevention of the non-refoulement, which is basically that nobody should be forced to go back to a country where his life or dignity could be threatened. We also touch upon briefly on Article 31 of the 51 Convention, which relates to non-penalization of irregular entry for those people seeking international protection. So I will leave it there for now, and I will hand over to my colleague Srijan. Happy to take questions as relevant.
Thanks, Jesus. Honorable members of the Portfolio Committee on Home Affairs, Deputy Minister, Deputy Directors General, the UNHCR appreciates this opportunity to engage with you today, particularly on the anniversary of the release of Nelson Mandela, an icon of human rights who walked free on this day 35 years ago. His release symbolized hope for oppressed peoples everywhere. From UNHCR's perspective, this anniversary underscores the importance of international protection and human rights. As we consider immigration, we must reflect on Madiba's values of justice, dignity, and respect for all, values central to the 1951 Refugee Convention, which South Africa is a party of. South Africa's history of displacement gives it a unique understanding of those forced to flee. This understanding should guide our deliberations. UNHCR's vital role in the lead up to and following Madiba's release as the first UN agency in South Africa, facilitating the return of exilees, is a powerful reminder of the importance of international cooperation. South Africa's global human rights advocacy, from Palestine to the DRC, must extend to all within its borders, including asylum seekers, refugees, and stateless persons. South Africa finds itself in a mixed migration context where various factors compel people to move. It is therefore crucial that the Immigration Amendment Act and its implementation consider the mixed flow and the varying vulnerabilities within it. It is our shared responsibility to ensure that any changes that are made are guided by the principles of international law, including the principle of non-refoulement, as my colleague Jesus has alluded to, and that they create a system that is both just and effective, one that acknowledges our shared humanity, reflects our commitment to international human rights standards, and contributes to a prosperous and harmonious South Africa for all, including those who have sought refuge within its borders. Esteemed members of the Portfolio Committee, we're here today to address the critical implications of omitting specific terms, which I'm about to screen to you. Specific terms such as asylum seeker, refugee, and stateless persons from the proposed Amendment Act, particularly in light of the interests of justice principle that is found in the amendment. The deliberate exclusion of these terms raises concerns about the Act's clarity, scope, and potential for increased litigation against the department, something which we would advise trying to include so that you avoid this. Without explicitly defining these distinct categories of individuals, the Act risks ambiguity and misinterpretation, potentially leading to arbitrary decisions and inconsistent application of the law. For clarity, let me reiterate, as in our written submissions, the internationally accepted definitions are found in our written submission. Asylum seeker is someone who has fled their home country and is in seek of international protection in another country, but whose claim for refugee status has not yet been determined. A refugee is a person who has been forced to flee their home country because of a well-founded fear of persecution for reasons of race, religion, nationality, political opinion, or membership of a particular social group, and who is unable or unwilling to return to their country of origin. I think the definition of statelessness was alluded to earlier, but much like Prof. Madonsela talked about Jabu, it is someone who is not considered a national by any country under the operation of its law. Indeed, if this definition is included in the bill, it may allow for the country to introduce a statelessness determination procedure, something which would be needed if persons who were found on territory have a legitimate right to be here. The interest of justice principle mandates that all individuals, regardless of their status, be treated fairly and equitably under the law. By omitting these definitions, the Act creates a legal vacuum that could undermine the rights and protections afforded to vulnerable populations seeking refuge or who are stateless within our borders. Furthermore, the absence of clear definitions may lead to protracted legal challenges as individuals and organizations seek to clarify their rights and entitlements under the amended legislation. This would inevitably result in increased litigation against the department, again, something which we want to avoid, diverting valuable resources and hindering the efficient administration of justice. In conclusion, I urge the Portfolio Committee to reconsider the implications of omitting these essential terms from the proposed Amendment Act. The inclusion is not merely a matter of semantics, but a fundamental requirement for ensuring clarity, fairness, and effective protections of vulnerable individuals seeking refuge in South Africa. Lastly, we would be pleased to share with this portfolio committee and those in this forum the forthcoming qualitative baseline research study on statelessness, which we have sponsored in partnership with the Department of Home Affairs and the South African Human Rights Commission once it is concluded. With that, Honorable Chairperson, we hand it back to you and welcome any further discussion from the portfolio committee for inviting UNHCR for any further discussion. Thank you very much.
Okay, thank you very much for your presentations. Colleagues, earlier on we resolved that we'll end our public hearing at 12:30. I'm advised that members may need to consider to travel from their place of residence to the dome or the parliament. And we're left with two stakeholders, including comments and questions that may need to be raised. I'll propose that, and members will guide that we adjourn the meeting. We then reconvene with the first two items in our next scheduled meeting, portfolio committee, and also all those who have presented will be in attendance for further comments and responses. We'll also request that the department must prepare and respond comprehensively to all the issues or submissions made by our stakeholders, and we'll then schedule a meeting for deliberation to take forward this period. I'm trying to propose to members that we may need to consider the approach we're establishing, given your guidance that we're now at the 12:30, towards 12:30. Yeah, can I check with members if the proposal is agreed? I noted that all of our including stakeholders, we've raised this matter and understand the pressures that are before members. Maybe let me start with the Honorable Ross and Honorable Machi, and also get comments from the last stakeholders if they understand the position we're taking, so that we have a fair and enough time to have presenters and also responses and comments on the subject, these important matters that we're dealing with. We've worked well in the morning with the other stakeholders and we'll give them enough time to respond. So to be fair, to also do the same to all our colleagues. Honorable Ross.
Thank you, Chair. Chair, I agree with the proposed approach. I think it's important that we're not in a position where we have to rush our questions and responses. So I'm in support of your proposal, Chair.
Thank you, Honorable Ross. Honorable Machi, I saw your hand.
No, thank you, Chairperson. I would like to second the proposal that we're prepared to leave. Thank you.
Okay. Can I get a sense if our stakeholders are comfortable with our proposal so that we don't... Mr. Matonzi,
Yes.
we're left with the...
Chair, we are left with the Clayville Civic Association and COSATU.
And COSATU, yeah. Can I get a sense and understanding if they are, so that they say to just take any decision in there? They've not commented on that.
Yes, we do understand CD Clayville Civic Association. We do agree with the rescheduling.
Okay, thank you very much. COSATU, Matthew?
Afternoon, Committee Chair. Members, no, look, we will follow the committee's discretion. If it's next week, Tuesday, if one would guess, we can make a plan. So I think we're available at the committee's discretion. Thanks, Chair. Thanks, members.
Okay, thanks very much, colleagues, and all the stakeholders who presented. We have not engaged or commented on your presentations. And in our next scheduled meeting, we'll request that you join us again, including those that have already interacted with members of the portfolio committee, so that we have sufficient ground on the issues that you want to empower members of the committee to enhance this amendment bill. And thanks very much, all stakeholders. Thanks the ministry, and thank also the department DDGs. I've noticed Advocate Malekate was in Matsaung in immigration. Thanks very much, and all members, thanks very much for your contributions to this important
Thank you, Chairperson.
the meeting stand agenda.
Thank you, Chair.